Personal yes. Is it today? Which I upgraded item number? We can have it as the first matter for disposal. Now there are certain orders matters, but that will be the first matter for disposal. For a proper hearing, we'll take this that matter first. Okay. Item number 37. Okay. Mon korbo. Yes. IA for vacating. Fifth. You file an objection, you will have it in the fifth till by. Okay. Sri B. Rahman Learned Counsel for the opposite party writ petitioner has prayed for time to file objection. Full stop. This court has, however, been informed by Sri S. Islam Learned Counsel for the applicant that the writ petition is fixed to be listed on 5/8/2026. Accordingly, matter is adjourned to be listed on 5/8/2026. Objections may be filed in the meantime. Interim order stands extended till the next date of listing. Yes. (11 to 16). Yes. There are similar matters. Okay, other side informed. Please give a list to our court master. Okay. It is jointly submitted in the bar that there are certain other analogous matters which have not been listed. Full stop. Matters are accordingly adjourned to be listed along with the analogous matters. The lead case being so and so. We'll give the and then analogous matter which are as follows. Which are give all the names. Okay, Zimandev. Give all the names. When? After 2 weeks? List after 2 weeks. 11 to 16. Okay. Yes. 33. Yes. 33 is for hearing. Where are you seeking adjournment? Okay. On a request made on behalf of Sri K.N. Chaudhary, Learned Counsel for the petitioner, matter is adjourned to be listed when? Listed on 13th of August. 12 is a Wednesday. Oh, 11th of August. 11th. Ms. J. Bush, Learned Counsel, is present for the respondent number 5. That's no, please. That's what list on 11. Yes. When do you want to move? Tomorrow? Okay. 51, 31. Why is it come for orders? Okay. Okay. A. Borua. On the prayer of Sri A. Borua, Learned Counsel for the petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit against the affidavit of the respondent number 3. List on on 21st of August. 21/8. Yes. What matter? Press matter. When did you file? Not listed as yet. Motion matter. You can have it tomorrow also. This matter pertains to this bench, bench 4. Okay. Motion, yes, motion allowed. Tomorrow, yes. 19. Yes. After? Why? Who is the youngest counsel? Okay. Other side? Mr. Gupta is not there. We'll fix up next week. Okay, next week we'll decide. Okay. On a prayer made on behalf of Sri H. Gupta, learned counsel for the petitioners, matter is adjourned to be listed on. We'll have it on 7th of August. 7/8. You are NH Ahmed. You are not on record. Are you on record or not? So, Ms. U. Das, Learned State Council, and Sri N. Jaman, Learned Council for the response number 8 are present. Okay. What is the urgency? Sealing. It's already sealed. If it's already sealed, how do we pass an interim order? Okay, we can try today, but we have to inform the other side that you'll be moving unlisted. Have you informed them? No, you have to move. Tomorrow you can move it. Move it tomorrow. Okay. Huh? Motion is motion all allowed. Yes. 20. On behalf of Mr. Here for the IOC. What is your prayer? What do you want? You have filed your affidavit. Filed. Yes, other side. Who's the other side? Have you informed the other side? On a request made on behalf of Sri N. Barua, Learned Standing Council, IOC, matter is adjourned to be listed on 12th of August. 12/8. Yes. On a request made on behalf of MSKDB, Learned Council for the petitioner, matter is adjourned to be listed on 5th of August. 5/8. Yes. Okay. On a request made on behalf of Dr. A. Saraf, Learned Senior Counsel for the petitioner, matter is adjourned to be listed on 6th of August. 6/8. Interim order past earliest tense extended till the next date of listing. Yes, madam.
Item 35, supplementary list.
It was for 1 year. 5/8/25. Yes. Okay, then what has happened?
Is there operating? On inquiry, they have like March 2 markets into one, and it was renamed your lordship. Lordship will find it at an actual 2 page 27.
Hmm.
Whereas a detailed field inquiry conducted by the Kamruk Jila Parishad region, the two markets namely Jahirpur Animal Market and Jahirpur Weekly Market, situated under the Jahirpur Gauhati Panchayat, Boromari Development Block, have been functioning at the same place and in the same day for several years. Whereas the inquiry further established that the same markets are in fact one and the same market but have been shown under two different names and settled separately at an abnormally low value, resulting in considerable loss of government revenue over the years. Whereas the inquiry also revealed that the actual annual settlement value of the state market is more than so and so. Whereas the matter has already been brought to the notice of the Commissioner of Website and Development, Government of Assam. Whereas the Standing Committee of Council of Jila Parishad, after careful examination of the inquiry, findings the interest of safeguarding government revenue, resolved to march the existing markets in a single market. Now, therefore, in exercise of power on the square so, government notification and instruction issued from Director by relation to the management and settlement past market so, Lordship Fantasy, Clause 1. The existing Jaipur Animal Market and Jaipur Weekly Market share with immediate effective cricket is one single market. The unified market share has been known as Jaipur Agriculture Animal Weekly Bazaar. Anywhere, sometimes value of the unified market is ever fixed so and so. The existing list is permitted to continue operating Lordship Fantasy notice part. Continue operating the market only for the month of July 2026. Subject to payment of the full installment for the month of July, calculated on the revised annual settlement value of so and so. This temporary arrangement can remain valid only until the market is settled, Lordship Fantasy notice part, until the market is settled through the prescribed e-tender online tender process or until further orders, whichever is earlier. The block development officer, Boromari Development Block, should immediately realize the revised installment from the existing lessee, ensure strict compliance with this order, and take necessary action for settlement of the market through the prescribed e-tender process in accordance with the provision of aforesaid. Then thereafter, Lordship, I have submitted the request installed as my lord by the lecture 3.
What is your grievance, madam? Your settlement had come to.
Order was found. Page 31.
What is it?
Partial modification of office order regarding temporary operation of Jaipur Agriculture and the Bazaar. Whereas his officer earlier issued an order so as 47 for permitting the existing agency to operate the Jaipur Agriculture and Weekly Bazaar temporary for the month of July so and so, pending settlement of the market through prescribed e-tender so and so. Whether upon further administrative consideration and interest of action student uninterrupted management of the market, safeguarding government revenue and maintaining public government during the interim period, it is considered necessary to modify the post temporary arrangement. Now, therefore, in partial modification of the so and so, excess of power in section 1 so and so, relevant rules of temporary permission granted to the.
Okay, yes, madam. Extension, we have prima facie, we have in some matter 105 violation, and there has been orders of this court also not to go for extension. You run the bazaar by yourself, okay? Don't create third party and make the settlement as soon as possible. Give opportunity to all the eligible bidders, including the petitioner if he is eligible. Okay. Okay. Heard Miss B. It did even. Heard Miss B. Bhuya, Learned Senior Counsel, assisted by A. Atreya for the petitioner. Full stop. The petitioner was settled with the, what is the name of your bazaar? With the Jahipur Weekly Market wide for a period of 1 year, wide and order dated 5/8/2025. Full stop. The grievance of the petitioner is that apart from two markets being amalgamated, comma, there is no process initiated for settlement of the market, and the same has been given for temporary settlement in favor of the private respondent. Full stop. The Learned Senate Council has alleged violation of Section 105 of the Assam Panchayat Act, as well as directions of this court in the issue. Para. Let notice be issued, returnable on, we'll have it on the 28th of 28/8, 2026. Miss P. Thapa, Learned Counsel, appearing on instruction of Sri S. Datta, Standing Counsel PNRD, accepts notice on behalf of respondent numbers 1, 2, 3, 4, 5, 6, 7, 8. Extra copies be served. Let steps 9 speed post PD within 2 days. Para. The Learned Senate Council for the petitioner prays for an interim order. Para. Considering the facts and circumstances, more particularly the prescription of law laid down in Section 105 of the Act, comma, the impugned order dated 5/7/2026 is stayed until the returnable date, full stop. The authorities, however, may run the market. The authorities are directed to take steps for regular settlement in accordance with law until such time run the market on its own. Read with. Okay. Okay. Accepts notice. Ms. Thapa, the Learned Council has, however, informed that steps are being taken for regular settlement of the market. Read with 105 read with rule 47(1) of the rule rule 47(1) of the Assam Panchayat rules. Okay. Print to mutatlo divide. Okay. It খুলে দিবেন। Yeah, just a minute. So profit loss. Yes, please. Yes. 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 Yes.
The first point, I asked, which is 4.2. That was the first point.
Correct. Correct.
And then we have shown that these, the profit and loss account auditors report for the last 5 years, 2023 was under 4.28, which has to be read with 26 gross 26 at least 55. Because that 26 gross 26 55
Yes.
was the examination of which and determination of responsibility.
Yes.
So because it relates to 4 and 3 eligibility. So my first point was that, and I have shown for this on more. What is the stand which you have taken in my petition at paragraph 9 and the affidavit that has been filed by the GTC was on the paragraph 14.
Correct.
And you also recollect that my stand was that you have not alleged those 5 years profit and loss as well as the auditor report for the last companies, which is according to me, it is a mandatory course. And I have demonstrated all those minor which are the profit and loss account and those balance sheet from their minor big document,
Hmm.
from big document or respond of person. I don't know a couple again into it.
No, we remember. Yeah.
And coupled with that, our argument before this order before was regarding about how the BGCN assessed. The paragraph 14 last 3 lines is they have said that it was assessed on the basis of the turnover given by chartered accounting certificate. So the first point is that whether it is permissible or not. Whether it amounts to create an exception, that's the first argument. To create an exception to the private response. The rules of the terms and condition that has been laid down by the authority, namely the BGC. That's the first point. That will amount to violation of Article 14. Excluding, and you decide that point, which was on the terms and condition of the tender. So it will be an exception which has been created to the private response. That's the first point. Now I just move it to the second point. Second point is clause 4.7, page 46. At page 46, clause 4.7, that's the second one.
Page
Page 46.
46.
Page 46.
Yes.
It's if you're watching into 4.7.
Hmm.
And see the second last of bullet point. Made misleading, made misleading.
Correct.
Even though, I don't kindly see on before that, even though the bidders meet the above qualifying criteria, they are subject to be disqualified if they have made misleading or false representation in the form statement and proves submitted as proof of qualification required. And on record of course, we are on made misleading or false representation.
Okay.
Now, where is the misleading? Where is the misleading or false representation? That demonstrate that where is that? Now, if you're watching now, probably if you're watching with 426, there's the big document of the private respondent. 467 question.
Four, five, seven.
You see my lord, the assessment year. That's financial year in 2022-23. Now, please see the 31st of 2023. That's the balance sheet if your lordship looks into it. This mark is 8 crores, 8,590.81. Only immediately on 31st, 2023, if your lordship mark 6.
Where is it? Where?
Right hand side of the top.
Top. Yes.
Right hand side of the top after for the year ended March 31st, 2020.
Yes.
Please see mark 8,590.8.
Yes. Yes. Yes.
Now, 460, please look into it.
Page 460.
461. 461. Now, this is annual turnover report. If your lordship looks into 461, it is 8,48590. That's the minor. They are maintaining it.
461. 461, which 461, which one?
On the top,
Top.
side column,
Okay. 8859.
profit and loss account,
Yes.
which your lordship I have just shown, 457. It has to be 461.
Yes.
Sales is a turnover.
Yes.
Lordship marked it, yes, now. This turn to 480.
480.
484.
484.
485. Please see 485. That's the balance sheet for the year 2023. 2023, my lord. If you are also using to 485, please see 485
Yes.
and see the for the year ended 31st of March 2023. Now, if you are also noted down on the right hand side, first particulars, I say, now the figure exactly is 22 85 90 831. 85 90 831.80 is fine. 22 from where they got that 22 first. If your lordship looks into 457, please take it 1 and 457 minus.
Yes.
And then 31st of March. If you turn in 1 hand minus final 457 and 485, the figures are different. Where with 457 and 461. If you also for it, keep it in 1 hand 485 and please turn to 457.
Yes.
The figures are different. Figures are different. For what purpose these figures has been given? Now, together, this is the first dissemination they have made. I don't know. They have to say why it has been done, for what purpose it has been done. But on the face of it, when I checked, I found this is a dissemination because they said minority for lordship looks into 4.8, 4.7. It has been mentioned it. Means you can disseminate representation. Any form in accounts, statements. So what I found in this statement is dissemination has been mentioned. Now I will take your lordship. 485. The same your lordship is looking into 485. Please take 485. Please go down below. See the CA and see the UTN number. UTN. See the number, my lord.
Yes.
This is the number.
Yes.
What you got it?
Yes.
Now I'll follow the code with my reply. Total you get it. Please take at 625. 625 of my reply. Affidavit reply. Affidavit of each item respondent. This is 625.
Yes.
Now, see it, my lord. This is for the 2000 assessment year PC. This is Form 3CB, my lord.
Yes.
Form 3CB.
Yes.
And PC5 down assessment year 2023-24, which is in 457 days of 8 crores and odd amount. And in another is saying 23 crores. But this will make it very clear. And please see, my lord, the UDN number now here. Please see the UDN number here.
This is of which entity?
2023-24.
This document pertains to whom?
This is the petitioner, my lord. This one is report number 4.
Now, from where do you get his name?
My lord, this is the CA, my lord.
No, CA.
Respondent.
CA is some Bajaj.
Yes.
Now,
And total turnover is same. Why not we
no.
count-
From where do you discern that this belongs to the respond number 4?
I just inform you about. Wait for a moment. Why not?
Just trying to trying to get his name. Actually, I'm not finding the name.
Yes. Your lordship sees a figure it matches. I'll tell your lordship. Your lordship is finding it from where his name reflects.
Correct, correct.
You'll find it next page 626.
Yes.
Financial year, that is 2022-23, which is the assessment year of 2022-24. This is the private legal name. Can you see my
Yes.
lordship? What?
Yes.
Yes, it's a legal. Now, what I want to show it, please look into another 625 again, madam.
Hmm.
And if you see the UTR number, please see the UTR number here on the top.
Yes.
See the UTR number on the
Hmm.
top. And if you please compare with the UTR number at 485, where they have got 22 crores. Please see 22 crores, where they have shown.
Yes.
See all different UTR number. And there they have for 22 crores. And here it is shown whether this is the income tax and GST return, where they have shown 8 crores an odd amount. UTR number is different. So that of those UTR number that is reflected in 485. So for what purpose they have given here one showing that 8 crores some odd amount, and here it is shown at 22 crores. And UTR number is different. And if you turn to again, page 626.
Just a minute, please.
Here.
Page.
Page 626. 625, I am for that research. Page 626. These
Hmm.
are GST return. You cannot find the actual figure. And if you see at A, column A, figure is 885. That's reflects same figure. 885.
Where do you get?
And that's on the right hand side. A, serial number, reconsider turnover declared. At page 626.
Yes.
On the right hand side.
Yes.
Figure, which matches
Yes, yes.
that figure.
Yes.
So now two things here. Why you misrepresented putting a figure of 22 crores? And UTN of 22 crores is different, and UTN number of 8 crores is different. And so GST will reflect. Correct. Why this figure of 22 crores? In 485. Well, on the face of it, I have seen it was when it was moved, and this was I 500 that was moving this matter before the honorable single judge. On the face of it, that was one of the grounds where it attracted the learned single judge. There was an order passed on this figure. They have to explain my private response.
Otherwise, to meet the qualification, what should be the turnover? Is there any prescription?
Yes. For last 5 years.
Hmm.
Any of this year, 50% of the total contract.
Yes.
It is absolutely no doubt of it, they qualify.
Hmm.
Of that 50% of the last 5 years.
Correct.
Any of the year.
Hmm.
So one of the year you calculate 50%, they qualify. There is absolutely that's no problem at all.
Hmm. Hmm.
I am not putting that point also
Hmm.
in this case.
Hmm.
This is absolutely no problem. Now this is why I have shown. Because 4.7H, it indicates if you qualify also, is it or misrepresentation, in any of the statement account, that will lead to disqualify the bidder. That's the point I have shown up to the court. Now, where I have taken this point is being taken in my repetition. In our reply, I'll show the first repetition at paragraph 10, kindly see my note. At paragraph 10, at page 11 of my report. This is the second point. The statement which has been covered in the repetition is paragraph 10.
Page?
Page 11, paragraph 10. Let us regard
Yes, please.
making misleading and consequently the financial statement and those are submitted as a proof of political requirement by the response of question state as parties income of financial record of financial year 2022-23 financial year 2023-24. A bare pencil of this financial report reflects serious discrepancy in the financial document submitted the court. There are many discrepancies related to turnover claim for the financial year. Supporting document for its establish self-financial agency. Now, the petitioner says the audit report financial statement, profit and loss statement, and balance sheet furnished by respondent for financial year 2024, 23-24, turnover revenue operational sales reflected as previous year figure.
Yes, we have seen this. You have made the pleadings.
I want to show that
Hmm.
whether we have taken the stand or not. Now, to that, the BTCs is 571 is there every day. Got it, man.
Yes.
Now, what they said that with regard to 10 of it, the NCA report denies the correctness of same. Chartered accountant certificate, it is so and union number so and so issued. The chartered account form so and so certified. The total annual turnover of so and so for the past 5 years, past financial year under, which was shown initially my lord, financial year and turnover. And a whole case is based, if you see on before that, on the before 15, the tender regulation considers CA turnover as your primary document. So they mentioned. Now see this. Furthermore, as per clause 4.58, which is already annexed and annex of one of the meeting documents, bidders minimum annual turnover, financial turnover should be 50% of the NIT value of rupees 22,21,970 in 1 year. Therefore, the minimum qualifying turnover criteria is so and so. That is 50% of so and so in any 1 year. Based on this, it there is one of this found technically financial turnover for the year 2020. So either past 5 years, that documentary was mandatory. This was the first argument. So out of that 5 years, any of 1 year, 50% of total turnover. So they qualify. If you calculate any one of it, you qualify. That's enough. But they have not mentioned anywhere that why this figure of 8 crores and 22 crores, they have not mentioned. They have kept side. Now, please see my reply, which your lordship will find. Next one, 617.
Page 617. Yes.
My reply. Just 4 lines, 5 lines. The petitioner has placed on record.
Paragraph?
Paragraph 14.
14.
I said my lord is a contradictory. I don't want to read it. Contradictory inflated turnover is 22 crores, which is 8 crores 85, which is so in GST income tax. That's what I have. So this is clearly my lord has chosen documentary demonstrated the admission process. So that they should have catch hold of it. 4.78.
No, you have to rejoin to their statement made in paragraph 14. So where is your reply to 14? It is not your 14. It cannot be your 14.
Then, right,
It is on 14, so you have to.
14, oh, paragraph 10, there is a page 570. 571 is paragraph 15.
No, paragraph 14.
Paragraph 14, I have given a reply. Paragraph
So if you're 14, you have to see a reply, have to be a.
yes, yes, I have to reply. Paragraph, that is paragraph 14. I have given a reply.
R4. Who is R4? Who is R4? No, no, this is not this. 617 perhaps is not the correct page.
I'm sorry.
617 is the reply to R4. You have to show the reply to,
Yes.
not the correct page.
18.
You have to show your reply to Mr. Bhuya's
I'm sorry.
affidavit.
I'm sorry. I'm sorry. Paragraph 18. Thank you.
Page,
Paragraph 18.
page.
Yes. Paragraph, it will be 4, my identity. Yes. 598, paragraph 4.
598.
Paragraph 4.
Just a minute, please. 598.
Paragraph 4.
Just a minute, please. R3.
I'm sorry.
598. Yes, what have you stated?
That is the last statement in paragraph 14.
Hmm.
The desired space by responsibility. Upon the chartered accountant transfer certificate given and say, the only responsibility and contribute the express submitted. Not 4.3 of the instruction mandatory mandate submission audited services setting the profit and loss account, auditor reports of the last 5 financial years. The same determined mandatory attention and cannot be subject to diluted or overridden by a constitutional certificate issued by chartered accountant. Attempt of the record number 3 to 11 days create accountable certificate to the status of the primary document is arbitrary gross dividing condition and amounts to rewriting the terms of the tender which is referred to the income.
Hmm.
The tendering authority is bound by the constitution of the big document cannot introduce new criteria of relaxed mandatory requirement in favor of any bidder. The repetition further says static principle of law are segment. So the minor certain judgment of the Supreme Court was cited Michigan, F-Bonds, all the judgment, rubbers, and ultimately 600. If you see at page 600,
Yes.
the last 4 lines, does the attempt of response number 3 to treat a consolidated CS certificate as a primary document amounts to the permissible alteration of a tender condition, therefore arbitrary, illegal, violating Article 14 of the Constitution of India.
Okay.
Then regarding turnover, that's a reflector of 22 crores and 85, that paragraph 5. We have mentioned paragraph 5 has been equal 1 or replies. The statement may be so report and deny the statement reaches the figures reflected in chartered account certificate are themselves on a serious cloud and cannot be accepted as face value in light of very discrepancy in the audited financial statement submitted by respondent of court. The respondent of court, a confession is made to explain the material contradiction between this minor 22 crores and 8 crores. The repetition humbly submit such inconsistency is not a minor irregularity for the content defect, striking at the root of the eligibility of respondents of court, establish the manipulation, renders the brief liable for outright rejection. Now we mentioned about two judgments of the Supreme Court, reliance and Baptist conduct. I don't have to agree to that. These are the my lords, the reply which we have filed. Now, so far as the private respondent, These are the stands taken by BTC, our reply. Private respondent stand, in this case of 4.7, at 554.
Private respondent R4.
Paragraph 6 now,
Page
is 552. Now, 4.7, is 5 and 552. 552 and paragraph 6. It starts. Now, we are on 4.7
just a minute, please.
here.
552.
552.
Yes, paragraph 6.
6. Now, please look for the code.
The affidavit starts at page 549. 549.
And we are on 554. It starts paragraph 6. It starts from 552.
Yes.
And we are on 4.7. This is the second argument, 4.7. That is 554. Now provides 4.7 we have mentioned, provided that even if a bidder satisfies prescribed quality criteria, they shall be disqualified if they have made misleading or false statement in the form statement and so that this was operate as a safeguard against fraudulent submission, but presupposes specific finding of deliberate deception. It does not operate as a blanket disqualification in the proper inquiry. Now, they also say that that cannot be, but maybe, but it doesn't operate as a blanket disqualification case. Is 4.7.
Means outright denial is not there.
That's the.
It appears that as if they have conceded to this. But unless it is a deliberate misrepresentation, it will not operate as a blanket
Yes.
bar.
Yes, right. That's what my.
Denial is not there.
The relevant factor, why I'm saying as a part of terms and condition. There is no denial, absolute denial that is not there. But if you read this, there particular what it appeared, it clause operates as a safeguard against fraudulent submission. But presupposes specific finding of deliberate misleading. It doesn't operate as blanket disqualification properly. So that's what my lord is saying basically to base upon. 4.3 H and 4.7. My first point, if a lordship looks into the first point and decide on the first point, that yes, maybe it is, your lordship takes a view, it is not a mandatory. That's a different altogether. But if it is taken, well, it's a mandatory clause, 5 years, the turnover, the certificate of the auditor's report is not being furnished. And also, the 5 years profit and loss account is not being submitted. Out of 5, only 3 has been submitted to absolutely no document at all. So whether you can exclude it, whether the exception can be cut off, then my lord, the first judgment is will be Dayaram Shetty will come into the first, 1979. You don't have a qualification, but you brought someone who did not have experience in catering airport, but they have an experience of running a hotel. So that is the exception which has been carved out. To the FS code, you can't do it. But that was a case different that they operated, it has been treated as per the process, we are not looking into it now. My lord, your lordships, now the judgment, coming into judgment, what is the scope of the judicial review? Now the law, my lord, had changed from the beginning until today. Now what we find, my lord, earlier judgment, right from there, or Express Sri Lanka Vidyarthi, Mahavir Auto is changed into Tata Cellular. Tata Cellular again comes into different judgment. Educo, Michigan, all those judgments final. Now what I find, one judgment, Jagdish Mandal, my. Jagdish Mandal, again, my lord, if your lordship looks into it, our case, the fitted judgment, which I subject to your lordship examination, is 2024 responsible. That's the judgment I place before this court. I'll place before this court.
Citation?
That is, yes,
2000
2024, 10 SCC case 273.
Name?
Consider Construction Private Limited versus Bharat Coaching Group.
Paragraph?
No, my your lordship is very particular when at the last occasion when I came, when I was arguing, then your lordship has indicated what is the scope of division, number one. Number two, your lordship has asked, at what stage you have completed? What stage? The technical piece open. After technical piece, at what relevant point of time I think I missed one submission before the judgment. I will place it one or two judgment. I will not take much of the time. One particular that last when your lordship has put me a question to it, when a technical bill was open and a financial bill was open. I think that's when I have put it. I just skip one argument to it. I have written when I give before. Yes. There are 15 and 16 week ID located by reposition. There are 15 and 16. I see paragraph 15 and 16.
Yes.
I missed that last point.
No.
That the petitioner reiterates that technical qualification summary sheet was uploaded on official portal of 35,000. Upon perusal thereof, and immediately upon securing knowledge that a private customer number 4, namely Gauhati Prasad, has been declared technically qualified, petitioner with utmost promptitude and bona fides apprise the respondent authority on the material facts and circumstances which unequivocally render the technical need of the said respondent liable to the outright rejection. Notwithstanding such intimation, the respondent authority failed and neglected to take any policy or remedial action for cancellation of technical fee. Response number 4. Finding no alternative remedy, the petitioner engaged the legal counsel who, acting under the instruction, issued a detailed legal notice on 1/6/2026 to respond to 2 and 3, calling upon them to forfeit review and set aside the technical qualification granted to Mohammed Gauhati Prasad and disqualify him for non-compliance with mandatory eligibility condition and submission of false financial information, which is, my lord, with the legal notice at page 545 can mark the legal notice at 545.
Yes.
That's the legal notice where proper steps was taken. Now please see at paragraph 16. One more paragraph I have done with paragraph 2 paragraphs I have done with the facts and the replies. Please see again paragraph 16, paragraph 16. The petitioner further submits on 2/6/2026, the petitioner personally visits the office of chief executive with a bona fide intention of submitting a copy of the associate legal notice of where the other short and dispute was already informed by the official respondent that the financial fees has already been opened and the respondent number 4 having emerged as the royal fees were likely to be awarded the contract under the tender process. Such disclosure made without any prior intimation to the petitioner reveals a manifestly uncritically and opaque approach on the part of the respondent. Now, if the lordship looks into 23.8 clause, 23.8
Page.
on the page 23.8 is page 54 of the report. (23.8) Roman 3.
Yes.
The evaluation Roman 3. Employers will inform the bidders whose technical fee is not responsive of the date, time, and place of working on financial fee. Bidders will inform or requesting may attend the meetings of the office of financial fee. So our specific stand is that we were not aware of it, but neither it was informed to us. And which we have quoted this particular at paragraph 70. That paragraph 70 is 70 is that we quoted in paragraph 18. I quoted this 23.8 and paragraph 18 says kindly see. He said that is a mandatory provision. So proceeded to the final industry at page 18. Open the financial fee. This is our stand which has been made. That was the precise question that was put forward to me by the government, by your lords. So these are the 3 points to which in the last day your lordship has put forward. So that's what we have affidavit and reply we have given. Now this thing is judgment of consider. Consider constructions. This is the judgment. I'm just talking because facts, some facts is important in the judgment. I think I find that it will become similar, this particular judgment. I find, subject to your logic.
Paragraph.
Paragraph 2 kind of similar one. Facts I will show it what only. Paragraph 2 is small paragraph. Or consider paragraph 2. I'll supply this copy. This short question that calls for consideration before this court is whether the respondent Bharat Court for justify rejecting the technical fee of the appeal while accepting the technical fee of respondent contribution and declaring it to be successfully given. Though respondent number 8 does not comply with the mandatory requirements of submitting the important documents relating to qualification criteria as contained in clause 10 of the tender dated 16/8/23 and thereby has failed to qualify the criteria laid down there. So I think my clause 4.38, whether it is a mandatory requirement. So that was under examination by the court. Before the Supreme Court. Now, paragraph 7 is the paragraph 7. 6 times is the paragraph 7. My lord, this is illegal. Here also two technically qualified. My case here also two technically qualified. Please see paragraph 7. Plus 6. Technical fee of the same tender was open on 4/12/2023. After evaluation of the same, applicant was declared to be technically disqualified on 6/5/2024. As per the tender summary report, letter 7/5/2024, technical bid of the Athena State was rejected on the ground that it does not comply with clause 10 of the NIT. So and so, so and so. Now 7. The financial bid of a two technically qualified bidders were opened on 7/5/2024 and respondable A company was declared to be a successful bidder. Appellant being agreed by the same decision of respond number so and so has filed a writ petition before the High Court, which has been dismissed by the High Court by the interim order. Now, my lord, will kindly see. My lord, this decision after technically technically qualified, financial bid was opened, and thereafter the award, the contract was also awarded. Thereafter, they came up before the court. That's why our lordship was asking that to what extent a judicial review, because what we find that there are few judgments of the Supreme Court, to what extent a technical bid can be examined by the court. What I find in this case, my lord, technical bid, both qualified, financial bid, after the financial bid, contract given, award given, thereafter it came approach. Now, if your lordship looks into paragraph 16 now. Paragraph 16. It is also not disputed, paragraph 16. It is also not disputed that the technical bid was opened on 4/12/2023 and the appellant was declared technically disqualified on 6/5. Then extract of tender summary report dated 7/5 is taken with the following remark. Did not comply with the clause 10 of the so 7. It is also not disputed. Respond number 8 has not submitted the scanned copies of the audited balance sheet required to be submitted as per clause 10 of the NIT in relation to the financial capacity. While submitting, uploading the tender document, and that it was only when the clarification was sought from respond number 8 about the shortfall of the document, the same audited balance sheet was submitted on 17/4/2024 after the technical bid was opened on 4/12/2023. It is further not disputed. Financial bid of the additional two technical qualified being opened on 7/5/2024. Respond number 8 company was found to be successful bidder. Now please see para 20, my lord. Now see para 20. Para 20. From the bare perusal of the aforesaid clause 10, it is clearly transparent that bidders were required to furnish the information and a scanned copy of document relating to qualification criteria, particularly substantiate their financial capacity. For the purpose of substantiating financial capacity, bidders are obliged to submit a scanned copy, self-certified notarized of the audited annual reports. For the last 3 financial years, or past 5 years in our case, as chosen by the bidder, comprising of the audited balance sheet and profit and loss account of the bidder, along with other documents stated therein. This was the mandatory requirement of the NIT. The same being related to qualification criteria and also transfer records so and so. 21. Admitted in respond number 8 has not submitted a scanned copy of the audited annual report for the last big financial year at the time of submitting, uploading the big document before the last date fixed on so and so, and the same was submitted on 17/4 only when the clarification was sought from respond number 8 after the technical review opened on 14/2023. Now 22 minor, when the technical bid of the applicant was rejected by the respondent on 6/5/2024 on the ground that it did not comply with clause 10 of the NIT, namely part 1 cover wash, other things 1 to so and so. There was no justification on the part or response of that report accepting the technical bid or response of A, which clearly not in compliance with the same mandatory clause 10 of the NIT. Respond of BCCI has visibly failed to justify as to how the technical bid or response is accepted when it has not submitted the requested important document relating to qualification criteria as mentioned in clause 10 of the NIT. Now, my lord, will kindly see paragraph 27, my lord. Please see para 27, there are 3 paragraphs only. Para 27.
Yes.
The same action of the respondent BCCL in rejecting the technical plea appeal was absolutely extraneous ground, accepting the technical to respondent, those submitted in other non-compliance of the mandatory requirement in clause 10 of the NIT, and subjects calling upon respondent to furnish the shortfall of documents after the opening of technical appeals was totally arbitrary. Here, my lord, pausing for a moment. Here, even chance was given. Then he submitted, the Supreme Court said that no, you can't do it. Once you have missed the bus. Here is a case where you did not submit our case. Now, para 28. There cannot be any disagreement with the legal proposition propounded in the category of decision of the court relied upon by learned counsel respondent to the effect. The court does not sit as a court of appeal in a matter of award of the contract, and it merely reviews the manner in which the decision was made, and that the government and its instrumentality must have a freedom of entering into contract. However, it is pretty well settled that the decision of the government instrumentality must be free from arbitrariness, as must not be affected by any bias or equation by nullified. Now, 29, government bodies being public authorities are expected to uphold fairness, equality, and public interest, even while dealing with the contractual matter. Right to equality under 40 aborts arbitrariness. Private authority have to ensure that no bias, favoritism, or arbitrariness is shown during the bidding process, and thus the entire bidding process is carried out in absolute transparency. Now, last, there are 37 by the C. What we learned, the Supreme Court now decides as para 37. 37. The submission made by the learned counsel for the respondent that the project in question, please see my lord, project in question being infrastructure project and also one of the mega project, the court may not interfere more particularly in view of the fact the agreement has already been entered in between the respondent BCCL. Special purpose vehicle of respondent cannot be accepted. When we have found implementation of the respondent was grossly arbitrary, illegal, discriminatory violation of Article 14 of the Constitution. As well earlier, government bodies, instrumentalities are expected to act in absolutely fair, reasonable, and transparent manner, particularly awards of this project. Any element of arbitrariness or discipline may lead to employee of the entire project, which would not be in the public interest. In that view of the matter, implementation of respond numbers for instance, in rejecting the and further details respondent interest action is set aside. Any action proposed undertaken agreement entered in pursuant of also stands set aside. It is also open to initiate test tender, so instance. So here my one step ahead. They did not comply with those steps in the present case, and they submitted after the technical bid was over. Now financial bid was open, and the FS said, no, you can't do it. These are mandatory clause. Financial statement, audited balance sheet, these are important to show the strength of the bidder. This was not done. So I think this is the judgment, my lord, which I really want to rely on the before this court. And moreover, my lord, the Apol's central court fee, it is on the basis of terms and I don't want to trouble your lordship. This is for a night. You cannot carve an exception under article or give a benefit to a particular person. This will be another argument, second. But if this argument, my lord, first argument, 4.3H, whole set is the mandatory, which they have not considered, they have considered bigger to document, my lord. Then ultimately, my lord, that will lead to, my lord, rejecting their, my lord, technical view. That's my submission. I'm deeply obliged. I don't know if trouble with all judges under everything. The latest judgment, that's why I'm not the right person. Before, can I just take your The dates are very important in this case. My lord. The NIT was about from 70 to 2026.
Yes.
And 2/3/2026, its submission was over. That means thereby all minor through e-auction, all documents, everything has been loaded by. I can see his document, he can see my documents, everything is visible. Now, thereafter, my lord, on 27/5, this technical big evaluation meeting was held. Till 27/5, my lord, in spite of having some apprehension with regard to some documents submitted by me, no finger were raised.
Not me, by the responsible for.
Yes, the other side, my lord.
You cannot,
No
you can, you
Yes.
cannot
Yes.
equate yourself. You are the decision making maker.
Yes.
Both of them are as per.
My lord, technical with evaluation meeting.
More than 2 months.
Yes.
More than 2 months, they did not say raise any.
No whisper of any with regard to the documents. Then 27/5 intimations with regard to bid finding opening also and financial bid opening minor. And thereafter on 35/2026, financial bid was opened.
35
35.
after 3 days of the technical bids.
So minor 27/5 and 35, 3 days is there. When the financial bid was opened, property statement which is generated by the system itself, it becomes L2 and the respondent becomes L1. What is the difference with regard to the offer that has been made? That is 51,20,353.7. L1 offered my lord 22, 70, 65, 446.30. And L2 offered 23, 21, 25, 800. The difference was 51,20,353.7.
This is a work for what?
With regard to this whole work, road construction,
Road.
improvement and upgradation.
Road construction.
Yes. For Gauhati under
Okay.
Assamala
Okay.
2.0.
Okay.
So with regard to this, my lord, on 1/6 itself, on when the financial bill was opened, it is a matter of record I have brought in. They sent in a legal notice on 1/6. After coming to know that they are not the L. And on 4/6, they moved this before this honorable court and got an interim order. Is the factual matrix with regard to this, my lord? Yes. Now, with regard to my lord, non-furnishing of the account statement for a year or two, my lord, and thereby issuing the CA audited reports, my lord. The law is very clear. If a person's turnover or a company turnover is less than a figure under the income tax law, then that is not necessary. That is the provisions, my lord. I think your law should directly include income tax acts, my lord. That is an exception provided under. Yes. 44A3, my lord. And that's been inserted in the year 2009 amendment. 44A special provisions for computing profit and payments of business on presumptive assets. Now, the exception that's been provided out here is this. Yes. Eligible business means any business except the business of buying, hiring, or leasing goods carries referred to
IT Act.
and
Asset.
Romantic, my lord, whose total turnover or gross received in the previous year does not exceed the amount.
You have not got your book, Mr. Bhuya.
This is my income tax account. But yes.
Amar,
So if the total turnover.
কোনখন? আমার কোন code? That is the code's copy.
Oh. I'm sorry, I didn't what the
Which one?
44 AP, my lord. That mark I have marked with.
Okay. Whose total?
Profit and loss balance sheet is profit. So it is not. My learned senior colleague referred to page 457 and 461. Before that, my lord, may I take your lordship? Two, my lord, this.
Can we again see what is the expression in the NIT
And I think, my lord, that expression, my lord, yes.
at page 43? Page 43.
The expression is, my lord, can you see clause 4.3
H.
H.
Yes.
My lord, may I read it, my lord?
Yes, please.
It's very important, my lord. When my learned senior colleague was making the submission, my lord has emphasized on this. Requires reports on the financial standing of the bidder, such as, this is very important, profit and loss statements and auditors reports for the past 5 years. This is a mandatory requirement for all bidders to file financial reports such as profit and loss statements and auditors report for the last 5 years. This never stated with regard to continuous last 5 years. That word is missing. Last 5 years.
For the past.
Past 5 years. And the income tax law says, my lord, that if it is less than 2 crores turnover, profit and loss is not required. Now, my lord, this has to be reduced 4.5A clause. I am reading it, my lord. Minimal annual financial turnover stipulates that to qualify for award of the
Where are you reading? 4.5.
4.5A at page 553.
Page 45.
Yeah. That's the clause of the, my lord, yeah, big topic.
4.5A.
A.
To qualify for award.
Yes. It was that to qualify for award of the contract, each bidder in its name should have achieved a minimum annual turnover in all classes of civil engineering, construction works only, of 50% of the DNIT value in any 1 year, i.e. rupees 60,098.98 over 500, which the L1 had.
Just a minute, please. To qualify for award of the award, each bidder should have, in the last 5 years, minimum financial turnover, achieved a minimum 50%.
The value. 624 something like that. 11 plus minus equal to the value. 1 year. 1160 is the L1 tag. Now, with regard to the disqualification that has been pointed out by my colleague, at 4.7 disqualification, my lord. Now, this system with regard to technical evaluation is over. No point of time, whisper of allegation. Even then, the authority can look into it. Because, my lord, that final decision with regard to issuance of, my lord, that job order, my lord, with regard to that order, is never been offered, that is there. So, my lord, can we see the allegations with regard to this with the mismatching of India and number and all? Sorry, India and my lord has been a structural part, my lord, with regard to this, my lord. In my application, I have clearly pointed out, my lord, that paragraph 14, paragraph 14 of my application.
Page,
my lord, 570.
570.
logic appreciates every document it's in the record. CAs are different. Audited reports are different. Persons has been given
570 paragraph
14 months.
14.
With regard to paragraph 9 of the written, the answer states that the respondent has submitted certain accounting turnover certificate having EDI number.
Hmm.
They are not anything this EDI number are false or false. It is correct. That is not the allegation. For the financial year 2021, 21, 22, 22, 23, 23, 24, 24, 25, dated 11/6/2025. The CA certificate is a professional certificate and the CA is a statutory authority under the Chartered Accountant Act 1949. The certificate bears a valid EDI unique document identification number, which is an additional safeguard against forgery. The certificate consolidates turnover of all 5 financial years and therefore consider valid compliance with the financial documentation requirements. And can you come to 15 again, madam? The Tender Evolution Committee considered the CA turnover certificate as the primary document for expenses. It is a document issued by a statutory authority, madam. Now, one line of argument was this, my lord, that the certificate issued have different EDI numbers.
Yes.
Different persons, different EDI numbers, my lord. What's wrong in that? If my lord is makes the my lord profit and loss statement, can be different. And on the basis of profit and loss, this my lord audit report is there. What's wrong in that? These are different persons, my lord. We can see while the CA name the EDI number are different. One is Tanaya Bajaj at page 625, my lord. 8 Tibriola 453. These are 2 different persons. Current years. And at 625 minor can we see document type CST and tax audit. Well, GST for a businessman, there are limited things, my lord, salary component and all such things. Turnover, profit and loss is totally different from my lord, the annual turnover. A person can have a turnover 1,000 crores, but he may sustain loss of 50 crores. That's a different issue altogether. Now, this is regard to GST. They want to confuse this honorable court, taking into account the GST. GST is total with regard to the input tax and all such things. And that's been part of my lord the whole profit and loss. Because it also includes salary component and other component. It's been in the statement of accounts. It's been reflected. Yes.
Just a minute, please. Wait, 24. Let us be clear on this UDIN. There are 2 UDIN which is specifically argued by Mr. Das,
Yes.
485 and 625. 5 and 625.
Yeah.
Since this UDIN pertains to the authority who issues the certificate,
Vishal Sharma.
this UDIN is not pertaining to the
VK Sharma.
whoever is. It pertains to the authority who issues the certificate.
My lord, this is with regard to profit and loss. This is not that audit certificate.
No, understood. The UDIN is of the person who issues the certificate.
Yes.
It is not pertaining to the person for whom the certificate is issued. Correct?
Yes.
So if you want to contend that since different persons has issued 2 different documents, their UDIN will definitely be different.
Absolutely.
So that difference in UDIN will not make any difference or any material change. Because this UDIN is not pertaining to the petitioner. It pertains to the person who issues the certificate. And this 625 is by another person. But 625 is by some Tanay Bajaj. Tanay Bajaj has got a different UDIN.
It's no complaint. And my lord,
And what about this 22 inflation by 22 at 485? The entire figure was 80 something 88, then suddenly at 485.
my lord, this is with regard to the balance sheet, 31st March 2023, my lord.
Hmm.
And my lord, you can see this, my lord. Salary to staff, level, all this comes into my lord.
Page.
Page 485 only. These are under different heads. And when I say, my lord, auditor issues a certificate of audit certificate, my lord, whose income is more than 50 lakhs, if an individual or a company is subject to audit certificate by the CA concerned. And for issuing a certificate, if it is false, criminally under the Chartered Accountant Act of 1945, it's a criminal offense. And these are technical things, my lord. And when the auditor have issued the certificate, balance sheet has been given, and some years balance sheet has not been given because it is not within the purview of Income Tax Act that under 2 crores not required. In that view of the matter, my lord, this L1 turns into my lord. And all such ground, when the previous occasion, they have never whispered about it. When they knew that they may not get it, my lord. And so because of that, this repetition comes in, my lord. Can we see paragraph 15, my lord? We have nothing to hide, whoever gets it, my lord.
Yes.
Paragraph 15 of my affidavit, my lord, will tell you.
Page
Page 570.
570.
571, my lord. That with regard to paragraph 10 of the written answer report, it denies the character of the sale and further states that chartered accountant so and so institute, bank and company accountant so and so. Notify the total annual turnover for the past financial years as under. This has been clear. And what is the requirement? That is 22-23 1 year. 22 crores 85,000. Whereas requirement was, final turnover was 11 crores 60 lakhs something. What's wrong in this, in the decision making process? These are all technical persons, my lord, all everything on right, my lord. Raising a finger, my lord, making an allegation is very easy, my lord. They have not deduced anything to substantiate this allegation. Income Tax Act law is clear. Audit report is been saying it's a false audit report. That is not an allegation. These persons are false, Wala, and all such things false. Because if you go to the site, my lord, their UTI number comes into, my lord, it is online. And they should have verified, and they have verified and found to be authentic. So they are not making a statement. And the language in 4.5 my lord H, such as. And if you want to interpret both the clauses together, and what is the requirement that a person having the credibility to execute the work? That is the requirement with regard to this document. And that, on the basis of documents, the authority has made the comparative statement only till now. In that view of the matter, my lord, whether this honorable court will interfere with regard to the whole tender process. What is the arbitrariness is there? Where is the illegal? Where is any quid pro quo they have pointed it out? Absolutely nothing. They have, a ground has been taken, my lord, at 27.5 with regard to opening of the financial bill on 35. They have taken a ground in this rate petition that 35, my lord, they were not informed with regard to opening of the financial bill. See the legal notice, my lord. Is it there? It is not. It's nothing but a lot of part. No, whisper. That is the last document with regard to the writ petition, my lord. Can you see it? Here legal notice, my lord. There is no whisper with regard to this.
This was under clause 28.3.
My lord.
The argument was based on 28.3 that there is a duty to inform,
Yes.
that it was violated. You say that there is no such averment in.
Everything has been computerized. If it has been a manual thing, manipulation comes in. Financial bit my lord, at the time my lord has been there. All computerized. My lord. I can see my lord, so far with regard to financial, I cannot see it on only on the date I can see. And when he discovers that he is L2, now this comes in. And in paragraph 21 of my affidavit, my lord, may I take your lordship, my lord? It is online, my lord. 572 page, my lord.
572, yes.
With regard to paragraph 16 of the writ petition, answering before and specifically and categorically denies the averment made therein, it is further stated that the entire tender process is conducted in the online mode. From the commencement of tender process, bidders could monitor the entire process by logging into online portal and assign the process tender at each stage. The status of financial obtaining known immediately upon obtaining the financial and certified. What more is required? And they say they have not been informed by the paragraph 22 specific categorical statement, my lord. They know about it, and as such, the legal notice comes in on 1/6. When they doesn't say with regard to non-informing of that. Everything is transparent, my lord. I have marked some of the records, my lord, with any appreciation. All is absolutely clear. So for terms of conditions of a tender process, tender document is not to be interpreted in a manner as a statute might. That's been a judgment day. Prohibitions. 501. 505.
What is the citation?
This is my lord, 16 assistance.
Current cooking.
Yes. Paragraph 50 is very important. Lastly, we deem it necessary to deal with another fundamental problem. It is obvious that respondent 1/6 to only enforce terms of NIP inherent in such exercise is interpretation.
Paragraph 14.
50, my
50.
50. May I read it?
51, just a minute, please. 50 at page 776. Yes, please.
Lastly, we deem it necessary to deal with
50.
problem.
Hmm.
It appears that response number 1/6 to only enforce terms of the NIP inherent in such exercise is interpretation of contractual term. However, it must be noted that judicial interpretation of contract is the sphere of commercial stand on a distinct footing than while interpreting the statutes. So if we read both the clause, what is the requirement that to ascertain that if the contractor is awarded, he can execute the work. He has the financial capacity. That's all, nothing else. Another judgment, my lord, like an old judgment, my lord. Paragraph 25, my lord. And this has been a trend, and to avoid this trend with regard to a unsuccessful tenderer comes and participates, and when he doesn't get the contract, he comes before the honorable, and to minimize it, my lord, paragraph 25, I am relying on it. The cost has to be imposed in such cases because these are the methods with regard to rules in public interest is involved.
Ronak, you are referring to paragraph?
25. May I read it, my lord?
Yes.
Therefore, Within such a stay order is mostly at the instance of a private party or even at the instance of body litigating in public interest. Usually in play order stop the project from proceeding further, must provide for reimbursement of cost of to the public in case ultimately the litigation started by such an individual or body fails. The public must be compensated both for the delay in implementation of the project and the cost escalation resulting from such delay. Unless an adequate provision is made for this in the interim order, that interim order may provide counter. That is the law with regard to this. And whatever my learned friend have, I think some of the law with regard to the states and which these are factually altogether different. Some documents were not submitted by lot and subsequently it was submitted. And that's why that is the law. This is every party has submitted all the document. Whisper of allegation till 27.5 no. Till 35 there is no whisper of allegations. In spite of knowing my credential and everything. All of the rectification is misconceived in view of the fact that the confusion is being tried to be put it on record to the extent that UDI number is different, this and different. Various person, I am a CA, I am a lawyer, my enrollment number is different, this is different. So what's wrong in this? That is why sum and substance.
Yes, Mr. Hawk.
I think the lead pilot.
Yes. R4.
What on that? That's in the equivalent of that 5 years of financial as a given to the 2 years standard. That does not necessarily under section 44 equivalent. That's now, what's the requirement? If your lordship comes to the it took a second is 45.
Of the writ petition.
Yes.
45. Yes.
Conditions. They see the minimum inner sentence turnover in one. Of civil engineering construction works only. Of KNET of 50% of the KNET measure. In any 1 year. Out of that 5 years measure, if 1 year is measured, exceeded measure, it will cover the more than 50% KNET. It will be okay. And in this case, I submitted 3 years measure, I did submit 2 years. 2 years since as a system 44 measure, 2 years no forgot. Since this turnover was less than 2 crores. If it is more than 2 crores, it could have been measured, it could have submitted. Since it is less than 44 crores measure, as a section 44 measure does not say. It is not correct. And other 3 years measure, I okay with it. Therefore, also edited. And since measure any 1 year is required. Out of last 5 years, only 1 year. Any 1 year covers measure more than 50% of DNIT, but I am eligible.
What is GNIT?
The detailed tender notice measure. Here the total amount measure was 33 crore. It was 22.88 crore measure. And 50% stamps to measure 11.6 crore.
Okay.
Now the stamp is 4.
453. This is for which year? 2021. This is for 5 years. The-
1.07 crore. So, under section 44 AD manner, the income set manner is less than 2 crore, so it comes at not. There are also manner, they have 21, 22 manner, here also we find 1.27 crore. It is also manner less than crore. So it is not necessary manner. And other manner, any one year, I have forgotten. I have more than that 3% gain. So I am definitely eligible manner. And requirement is for only 1 year.
So for the year 2020 to 23, your turnover is more than 2 crores.
21, 22 manner.
No, not 21, 20 to 23. 22 crore. So
26, 11.8.
no, the requirement, the exemption under the exemption under 44 AD is that your turnover should be less than 2 crores. So for 20 to 23 is more than 2 crores.
Yes, sir. I have submitted.
For that you have submitted.
I have submitted. Remaining year I have submitted.
Remaining years is only 1 year, 20 to 23. That is more than 2 crores.
2.83 crore manner, it also covers the year. And 24, 25 manner, 12.01 crore.
Okay.
It also covers.
Okay. First year it is less than 2 crore.
Yes. Second, this is.
Second is 12. This is 1.27. Then fourth also 1.18, isn't it?
Yes.
Fifth also 1.20. Only 22. 2.2.
Yes.
How many zeros are there? No, we'll come. We're just getting the clarification of the figures. 1, 2, 3, 4, 5, 6, 7, 8. 1, 2, 3, 4, 5, 6, 7, 8. For 2021 is 1.07 crore. 2021?
Yes, sir. 2021, 11.27.
No. 2021, 1.07.
Yes, sir. 1.07.
Then 1.27.
Yes, sir. 1.07.
Then 2.28.
22.
Not 22.
Can
2, 3, 4, 5, 6, 7, 8. Oh, no, yes, you're right. 22 crore.
Yes, sir. 22.8.
Okay. And then
11.8.
then 12.2. So last 3 years it is more than 2 crores. More than 2 crores. And first 2 years it is less than 2 crores. So you say that you are covered by 44 AD.
Yes. So the downwards have that it doesn't go with whether it is not necessary. Since it is excluded only on the
$45, what is the requirement? Oh, no. H 4.3H. Reports on the financial standing of the bidder, such as profit and loss statement of the loss statement and auditor's report for the past 5 years. Okay. Yes.
in 1 year. Which I have already have 3 years. So I'm covered. And because their documents matter. Well, at least they are the joint venture matter. The petitioner matter. Initially, this what matter was matter polluted 3 times. Initially, it's just matter it could not participate because it could not with the secret of the people. Subsequently, they have made a joint venture company matter. Prior to the floating of this agent matter to an extent. So, friends matter come together, form the joint venture matter. First, cover the situation of the TNP. Even that matter.
There is no, is there any bar to have a JV? They can, then?
There is some other equipment, equipment. Regarding what mix transfer, it is a very essential part of the it should be the name of the JV bank.
No, is this argument required? Because they have been held to be technically qualified. That is not put to challenge by you. Mr. Hawk, you meet the argument made by them, whereby they have criticized your holding to be financially responsive. Mainly, all 3 arguments have been made. 4.3H, you're not meeting the requirement of 4.3H. Argument on misrepresentation, that if there is misrepresentation, it will be out. And this misrepresentation has been supported by 2 different UDIN and the inflation in the profit and loss statement by 2 CAs. No, since the allegation is against you, they are the decision-making process. Mr. Bhuya has put on record what decision, how is it taken. Now the allegation is with your document. You have tried to argue that this document does not suffer.
There is it is already covered, but 6 years I have accepted. And so far the misleading or the mispresentation, the fact there is nothing to misstate. Since we immediate number on that matter, since if my lordship is I go for a voting report to a particular CML, when it is generated each immediate number is different, and subsequently if I go to the another CML, each immediate number is different. It is unique document identification number. And when it is authentically verified by a authorized CML, then Indian number will be different. Now come to the Indian the document number and come to page 298.
298.
Document.
Yes.
Here, lordship will find kilometer. The signature of the CA is there, but no EPI number. Its authenticity is also a question.
But we'll perhaps not go into this aspect because they're being the petitioner being held to be technically responsive and that not being put to challenge. You are just pointing it out that for their document UDN is okay.
Single miss. It is everything clear and cut matter on the record separate. Management in the there is no square value. And remaining was only 1 year. If 1 year covers time eligible. And since the tender evaluation committee had duly verified, and they had also ignored some mistake on their documents also. They have considered really. Now after having alone he has raised this, they have had this big issue. After evaluation of technical people, they didn't come in. The intent of CG 4 also low ELCK number. CG 6 also low ELCK number. Nothing. Only starter accountant. It has a seal of there. And over the this plan the equipment is concerned. So I am again pointing out that it is a mandatory matter for party to work. And this this plan that record that belongs to unequal body. And there is no agreement matter as such in the name of the joint venture.
Okay. Anything else?
Over
Okay.
this matter, it is more report matter.
Okay. Any rejoinder you'd like to? Just 2 minutes before completion. No repetition, only clarification.
Yes. Regarding this section 44 ED, the what's make I think from page 453 where the is very important.
453. Yes.
There is that as per section 481, 444 AE,
Hmm.
they are not supposed to give any original report or any in a area whether the otherwise present.
Hmm.
When the lordship already seen for the year 2020, 21, it's less than 2 crore.
Hmm.
And for the year 2021, 22, it's less than 2 crore.
Hmm.
But then also they have submitted the original report for 2021, 22.
Hmm.
Additionally, document they have submitted are nothing. Now regarding 2022, 23, I have we have already made the allegation regarding the manipulation of the profit and loss account. Should have been 8 crore. Now your lordship kindly come to 2024, 25. Here the turnover is always 12 crore. They should have given the original report for this thing. And this is the current year. Crucial and very important year of 2024, 25 for their financial standings. They have not submitted any documents for 2024. So the fee and the protection they need for section 44 AD is not available to them.
Okay.
My solution regarding this certificate. And now your lordship kindly come to page 625, where I read that they were into their separate media and but there is here of the PCS stated page 625 is object. The first before the submit on the thing this UDI your lordship right if it is UDI line will be different, UDI will be different, it's just other accountant that is understood. Now from these two documents, what I'm trying to submit over.
Yes.
What your lordship can take a case. Now they have a case, my learning senior for TCS a case that this document pertains to GST only, not to income tax. And for that he has shown the particulars regarding document types which says GST or remaining words are and tax only. And if your lordship kindly come to the next row itself, particulars of section of form under which report issued. This is form 3CB, section 44BA. It's an income tax act.
So what I am trying to put here, your worship, is that for the same year, for the same financial year, for income tax returns, same documents cannot be furnished by two separate chartered accountants for the same SST, your worship. That is my contention here. I fully understand the UTI numbers are different when the chartered accountants are different. But that is my plea. How can there be two chartered accountants submitting documents for the same financial year, for the same SST, and for the same documents? Very clear here. The documents they have sent particulars of section of form under which report issue, form 3CD. That pertains to audit report, your worship. So this is the audit report they have submitted under by a different chartered accountant, with the help of a different chartered accountant, and the document now, if your worship may kindly come to page 45.
Four eight five.
Yes.
Yes.
Here the chartered accountant is different. He is not the chartered accountant who had uploaded the form.
Yes.
I've shown already at 625. This is the uploaded form for audit report, which is uploaded by a different chartered accountant. Now, these documents, which they have furnished before the tendering authority, is again made by purportedly made by a different chartered accountant, because I guess the UDI is different and is different. Here the amount is 22 crore. This is the manipulative document you wrote. And if you lordship may kindly see, except this first 22, the figure 22, all other figures are same. They have just replaced the figure 8, the first figure 8 with 22, to make it look like 22 crore instead of 8 crore. That is my issue. The manipulation is very much from the tender documents itself. Whatever the documents, additional documents I have done is just to satisfy your lordship. But from the documents themselves before the tendering authorities, there are sufficient reasons to doubt the credentials of the private respondent number 4.
But this, see, Mr. Sharma, as a matter of fact, you may be correct. There may be manipulation. But this is certified by a chartered accountant who has got the authority. There is an UDIN number. There is a prescription of law laying down the consequence of giving. You can give, but prima facie, making a allegation of manipulation in a duly certified copy by the chartered accountant, can it be a matter which can be looked into by this court?
Yes, your worship. I'm submitting because that's what we have the different. Because your lordship very kindly now come to page 457 one.
457.
These are all the documents I'm doing which they submitted before a tendering.
Yes.
Why I am saying these are arbitrary.
Yes, yes.
457.
Yes.
This document is also given by chartered accountant.
Yes.
Again by a third chartered accountant.
No, this is Tanay Bajaj, not third. The other one. Tanay Bajaj.
Yes, this is what Tanay Bajaj. In this document, your lordship will find the amount is 8 crore. This is also authentic. So when there are two authentic documents showing two different figures, the tendering authority should have doubted the credential. This is my submission. How can the tendering authority be a judge upon the authenticity of two different documents?
Profit and loss. 2024. These are for two periods. This is first at 457 is ending March 31st, 2024.
Yes.
And 485 is ending March 2023.
March 2023 figure is also different. The last column you wrote.
Yes.
Here for the year ended 31st March 2024, 8 crore.
Yes.
8 crore is everywhere except page 485.
No, 8 crore. How do you support your statement that this figure of 22 crores or whatever on the right hand column which is from sales,
Yes.
pertains to the turnover for the year ending 2023?
Yes, you're paying the page 463.
Yes.
463.
Yes.
Yes.
453. Yes. Or 50. Yes, what do you want to connect 453 with?
22-23 at phase 453 for the year 22-23. The total is 22 crore.
Yes,
Got it, your working?
yes.
And at the same time, your working also kindly pay 23-24, 11 crore.
23, 24.
11 crore.
Yes,
Yes. Now your working may kindly come to 457.
457.
Yes.
Yes,
Here for 23-24, the amount is same as turnover 11 crore. The first column your working.
yes.
11 crore. Now the second column for the previous year, that is for year ending 2023, the amount is 8 crore instead of 22 crore. Now your worship may kindly again come to page 485. Here again the amount is 22 crore.
No, what under what head this this?
This is sales turnover. Because I have already shown at page 453 in the turnover certificate the amount is mentioned as 22 crore. And at page 485 the amount for same period. Exactly same. 485 and 453.
No, that we have understood. That extract at 453 by the CA for the year 22-23 has been extracted from 485. You are trying to make out a case that 485 and 457 there is a discrepancy.
Yes.
So discrepancy. Now we are trying to understand how is the discrepancy. See, 457 is a statement of profit and loss for the year ending 31st of March 2024.
It's not whether it's necessary or not, but it's a authenticated document given by the chartered accountant where he has mentioned that the amount is 8 crore. And these 8 crore is everywhere. In page 625, in page 485, everywhere. 461, everywhere 8 crore, except page 485, where it's 22 crore. Can never say that 457 is not authenticate and 485 is authenticate. Both are by the chartered accountants. Maybe it's different chartered accountants. And at page 625, I have annexed my document, the additional document, to show that the chartered accountant who has uploaded the document for the same previous year is the same chartered accountant who has given the 457. Page 457.
Okay. We'll consider.
And one take 1 minute regarding my knowledge about the opening of financial issue. On 30th at 5, after 5 p.m., they have opened a technical deal. On the very next day, early morning, I have given the legal notice. At that time, I was not aware that the financial deal was open. So,
But he says, Mr. Bhuya says it was on public domain. It is all on electronic mode, e-mode. So if it is opened, it's not required to be intimated like earlier times that you have to be informed. It's opened on e-mode, so you are privy to that. You can see that.
I am not agreed by the provision of tender documents whereby I should have been intimated prior to opening. I waived it. But regarding the contention of my learned senior committee saying that I have not taken a turnaround and come back tenancy because I came to know that I was not selected. That is not the case. Because on 30th at 5.
First year is your legal notice. You have seen that.
Yes, the very next day I have given the legal. And there is no question of spreading anything about the opening of financial deal because on first when I instructed my advocate to give a legal notice, on that day I was not aware that the financial deal was open. I approached this honorable court without knowing that the financial deal was open. Even if it was on public domain, that was only after I filed the petition here.
Okay, also.
So it is not a case that I have taken a U-turn after coming to know that I have been selected. This is not the case.
Heard. Sri D. Das, learned senior counsel assisted by Sri P. K. Sharma for the petitioner. Also heard Sri A.K. Bhuya, learned senior counsel for the BTC, assisted by Sri S. Sharma, N.R. Sharma, as well as Sri S. Hawk, learned counsel for the respondent number 4. Hearing is concluded. Judgment is reserved. Mr. Sharma, you have the records? Sri Sharma has also placed before this court the original records of the case. ऊपर तो लिखा था सर, judgment is hearing is concluded. Okay. Yes. So when do you want? Yes, we remember. Tuesday. Item number 9 and 10. On a request made on behalf of Sri K. N. Chaudhary, learned counsel for the respondent number 1 to 5. Matter is adjourned to be listed on 4. Three R. Sharma, learned senior counsel for the petitioner, is present. It will. Okay. Yeah, for whom? BTC. Why do you need time? Okay, when do you want? 11th. On a request made on behalf of Sri A.K. Bhuya, learned senior counsel for the BTC, matter is adjourned to be listed on 11th of August. Sri J.U. Ahmed. Sri J.U. Ahmed, learned counsel for the petitioner, is present. No, we cannot make it a this thing. Sorry. We're giving one doesn't mean that we'll make a mentioning hour at 2 o'clock. Yes.
2 to 5. There's a petitions for this non-payment of contractual fee. In fact, my lord, the work in question is funded by a part of is funded by the central government. They have filed their affidavit and the stand they have taken is that the central government has not here. Central government council is.
These are pending since 23, madam. How soon can you get the instructions? You are in all the cases, Mr. Heard 3 M. Biswas, learned counsel for the petitioners. Also heard Miss R. Deka. You write RM or R? R. Also heard Miss R. Deka, learned standing counsel, Water Resource Department. Full stop. It, however, transpires. No, don't say. 3 paragraph 3. Biswas, the learned counsel for the petitioner, has, however, submitted that from the affidavit in opposition filed by the Water Resource Department, there is a role to be played by the central government. Full stop. Miss M. Burman, learned counsel, appearing on instruction of Miss A. Gayan, learned CGC, however, pressed for some time to obtain instructions and to file affidavit in opposition. Considering that these matters are pending since long, 2 weeks' time is granted to enable the central government to file affidavit. Full stop. List on we are giving more time, 19th of August. Okay, M. Burman alage.
Item 6.
Challenging the order for DA.
Yes. Will you file an appeal? But appeal, is there any time period prescribed? That we can make some observation that since your writ is pending in the court for since 23, I think that will be a better option for you. You file an appeal, okay? Heard. We'll examine right now what is there. The standing council is making a submission. We do not doubt that submission. Please go through it. We'll have it after a while, Mr. Sharma. Go through it after a while.
Item 7.
But Mr. Sharma, this may not be the final order. If you think that appeal may not lie, then you can still press your petition. But if the appeal actually lies, then we'll send it back. Just check it after a while. Item number?
7.
Yes, Madam Dury.
And he was expired on 18/8/2021.
Pleadings are completed. Yes, we can take up this matter for disposal. Okay, 50. 50.
They have 40.
Oh. Then
Relying on the judgment passed in WPC 260 of 2023.
what has been held?
In this case, my lord, the petitioner is physically, my lord, disabled, my lord. So he would be considered on as party, my lord, cabinet, my lord, meeting dated 19/10/2021.
What is the outcome of the meeting?
In that meeting, my lord, that since the policy decision has already been taken by the state government in its cabinet meeting so and so, to exempt the fair price stocks having 50 or less than 50 ration cards, the owners of which are either widows and specially able persons. And here, my lord, in my case, my lord.
Then you can consider that. Okay. We'll consider that. Okay, we're going to consider. Where is that cabinet decision?
19/10.
Have you enclosed that? Have you enclosed that cabinet decision?
There are batch of petitions that have been decided not in the case of these are in the lead case also. It was decided that 2 exceptions were after for the.
No, otherwise cutoff of 50. We have a number of cases. We have upheld that decision that 50 cutoff is okay. But if she falls under the 2 exceptions, you consider her case. Yeah, okay.
Dependent on the fair price stock.
Okay.
On sympathetic ground.
Heard. Okay. Yes. Okay. Heard. Miss R.S. Deori, learned counsel for the petitioner. Also heard Sri R. Talukdar, learned state counsel, appearing for all the respondents who has also are all the respondents who has informed. No, all the respondents. Full stop. Considering the subject matter involved and also the fact that pleadings have been exchanged, comma, this writ petition, which is pending since the year 2023, is taken up for disposal at the admission stage. Full stop. Para. As per the facts projected, comma, the husband of the petitioner was issued a fair price license in the year 1982.
Yes.
82. Full stop. Put it, and was running the family from
In the year 85.
85, in the year 1985, and was running the family since then, running the family on the basis of the income earned. Full stop. The license was renewed from time to time. Full stop. However, on 18/8/2020, unfortunately, the husband of the petitioner had passed away, leaving behind the petitioner and a specially able son. Full stop. It is the case of the petitioner that the entire family was wholly dependent on the income earned from running the fair price shop. Full stop. The grievance of the petitioner is that the shop the license was not transferred to her name. Where is the aspect of 50-40 here?
On 24/9/2022.
Yes.
In this manner, it's number 33, next one. This was.
Yes.
With reference, I have the honor to inform you that in view of installation of ePOS devices in the fair price shops and implementation of the One Nation, One Ration card scheme in the state, and as per the decision of the state cabinet, it is necessary.
That is okay. How is it in connection with your claim? Your case is that your husband passed away, it has not been transferred to you. Where is your case that is because of the numbers being less than 50? That is not your case.
Yes, my lord. In party or my lord, act my lord, the license cannot be transferred. But on my lord sympathetic ground, my lord, the family depends on my lord.
So it is nothing to do with 50 or 40.
Yes.
So why are you taking out 50 or 40? You can simply say that you are the widow, you want consideration.
Yes, my lord. On completion.
You have not placed the case in the proper perspective, madam. This is not how you place your case. No. It's not a. We are not on that. On the right. The case law which you have relied upon, it's on 40 and 50. It's nothing to do with transfer. So how will this be applicable? That 40-50 will be applicable only when the applicant is a widow or a specially able person. Here it is not your case. So how will the office memorandum be applicable?
On my sympathetic ground.
Then you have to show some law
Yes.
that only on sympathy you can be granted.
Yes. On next date, my lord.
I'm prepared. Don't try to take support of a judgment to facts of which are entirely different. Wasted the time of the court, madam. On the request of Miss R.S. Deuri, learned counsel for the petitioner, matter is adjourned to enable her to seek further instructions. Full stop. List on Tuesday next, when an endeavor would be made to dispose of the petition.
Ultimate.
Yes, madam. What is the subject matter? What is it? What is Annex 7? None appears for the petitioner on call, whereas Miss A. Bora, learned standing counsel NHM, is present. Full stop. Even on the last occasion, that is 16/12/2025, there was no representation on behalf of the petitioner. Para. In the interest of justice, a final opportunity is granted to the petitioner to make representation, failing which, this court would pass appropriate orders. Para. List on Monday. Which respondent? CGC. What is your name? J. Bora. Miss J. Bora, learned counsel, is present on behalf of Miss R.D. Bill and its CGC. Mr. Sheikh. Affidavits exchanged.
Yeah, the authority taken by stance that no settlement of overhang of capital market is made because there is a ban from the council. You know, they do not place any document to that.
Okay.
Same thing, my lord, what happened? There is no development in all government area. Capital markets are set. Someone are exactly storing those documents.
Madam, you also get instructions? No, he says that there is new development. Okay. Sri M.A. Sikh, learned counsel for the petitioners, has submitted that there are certain developments which would have a material bearing in the adjudication of the present case. Full stop. Also heard Ms. B. Bora, learned counsel representing the BTC, and name A. Banerjee on behalf of Ardhar for the response number 2. Sri R. Talukdar, learned state counsel, is also present. Para. Matter is accordingly adjourned to enable the learned counsel for the petitioner to obtain instructions. Para. List on when, Mr. Sheikh? We'll have it on 12th of August. Yes. You require time. Why? Affidavit. You have filed your affidavit. HPCL, who is appearing? And Mr. Ahmed, you are appearing for whom? So you have also filed affidavit. You will file rejoinder. Rejoinder against R6 have been filed. Then HPCL rejoinder not filed. Okay, we'll file rejoinder to HPCL. Okay, we'll grant some time. Mr. Roy? Okay. 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 What is your name? R.C. Alam. Learned you are not on record, Mr. Alam. On behalf of P. Bharadwaj, Sri R.C. Alam, learned counsel, appearing on instruction of Sri P. Bharadwaj, renews his prayer for grant of time to file rejoinder affidavit qua the affidavit in opposition of the HPCL. Full stop. Also heard Sri S.S. Roy, learned counsel for the HPCL, and Sri I. Ahmed, learned counsel for the response number 6. Para. In the interest of justice, further 2 weeks' time is granted to the petitioner to file rejoinder affidavit as prayed for. List on 14th of August. 18th. Okay, 18th of August. Yes, Mr. Chaudhary, SP Chaudhary, NIT Silchar. Mr. Chaudhary is not seen nowadays. He has to be invited for matters. Mr. Talukdar, your colleague, Mr. SP Chaudhary, please call him. Please give him a call. After a while, Mr. Sawala. And 23. Very good. She wants for final disposal. He also wants for final disposal. No. She is always ready for final disposal. No. If you have a difficulty, we can accommodate you. That's not a problem. One day, 2 days, not 25 matter.
order, no property, but to a very limited extent. Therefore, and I don't think it will take much.
Green bus.
That green bus should be. Question is whether
You have been allotted alternative routes, if we remember correctly.
there are other parcels to accept. We said no. Because we have a right to continue.
But now, is there anything to be decided now? See, on principle, in principle, you have said that, if you remember correctly, that the change in the procedure or the policy to have a pollution-free environment, that has been done. You are only interested to have a feasible route, alternative route, so that you can also run your business, which you have been doing so since a long period of time.
Also pass them on. That conforming to the idea of order. You can, you what? You will tendency to put them in other route, just for particular temporarily.
Yes. Yes. Now, are you running the business now?
Most of them have sold out their risk. And some of them are still running and operating. Sometimes within this goes specified routes. As per
In that context, we are asking whether there is any live cause of action which will really be fruitful adjudication.
I suspect. Because here, and this is the same order. That is the 17th of November 2020.
Mr. Nath, you are for whom? State. So if all the parties are ready, we can make an attempt for disposal. Mr. Sahawalas, this matter will probably take some time. So after a while, Mr. Chaudhary has come. Yes, madam, where is Mr. Chaudhary? He should come. Every day is to be called. What is this going on? After a while, Mr. Sahawala. Yes, there are two petitions, Mr. Mahanta. Which one would you like to have? 7263. We take up the records of 7263.
The order was passed on 7/7/2025. Now we will take up that order first. This is the first case.
I have not received the applicant instruction regarding whether they have applied under the intake order first by this.
Adam, you are ready. Then we do not know. It's up to you. You came up and very happily said that you are ready for. Now you are saying do not have instructions. You cannot make inconsistent statement. And Mahanta has very gracefully said that though he is not fully ready, seeing your readiness, he has agreed to argue. And now you are saying you need instructions.
Point only that the body given to the petitioner to apply to this authority for alternative road. Whether they have applied that instruction, I don't have right now.
The process of applying and working
So Mr. Senior Counsel has said that few of the vehicles have been disposed of now, but few are still running in alternative routes. That is what he has said.
I think in the meantime, out of those 60, some more may have applied that they have that information, that exact as of that is not. That you can take. This is subject to the result of this.
No, that is why we were asked repeatedly, Mr. Mahanta, whether there will be any fruitful result would be served by adjudicating a case, even assuming we decide in his favor. He said yes. So if even 2 or 3 vehicles that are, if he says yes, we have to decide it. Unless, of course, it's a merely an academic exercise. That will not do.
Yo, answer question. Even if I'm compelled to switch off to another way, arbitrarily cancelling, they have compelled me to switch over, arbitrarily cancelling my license. What will be the problem? And if not cancel those licenses, then what is the public sector?
See, on the aspect of policy, our rules are slightly limited. And policy appears to be, at least prima facie expressly appears to be, in the larger public interest that you are switching off to a E mode, where to curb the pollution.
They told us,
Yes.
you said that sorry, and this is not possible for. So you people have to give us time, or else law provides the you will compensate. Here I am.
You'd be arguing on the balancing part, whether it was a balanced approach was taken or not.
Ultimately, if at all, for the greater cause of the public, I am compelled to switch over. I may at times have to do, but they will have to balance it. And the law provides for. They, the government here, what I think, taking it to contradictory stand. In one hand, they say that we are acting under section 72 of the MBA. We have a right, we have a power to change the terms of the permit, or it can sell the permit. Therefore, we have done under this. On the other hand, the resolutions in the regional transport for this day, we are acting under section 103 of the MBA, whereunder the licenses can be shortened, routes can be changed, it can be cancelled, or we may deny them.
But is there a conflict between the two provisions?
There,
Where is the conflict?
because under section 72 at any rate, they cannot change the route. They can change the conditions of the pump, but not the route. They can until shorten the distance of the route, but they cannot cancel or altogether change the route. And number three, second point, if they want that there is a larger question of public call, and they are referred to take a scheme for the good of people, then they would have to under section 6 of the MBA, and then they are referred to create a scheme, publish it, notify it, ask for objections, hear the objections, dispose of those objections, and then they can pass orders under section 103, restraining or cancelling, or even the terminating the permits already existing on those routes. So that power is then available to them. My initial case was that they have not acted under that particular sector. Those provisions were not invoked by them. Then if only in section 72 this is not permission. This honorable court after an order at time was considered right before. I have to go to the court passed an order allowing me to pay for here. And then this order came at 17 on 17 plus will required. Once you can find it that this becomes 6117 of 2025.
এই ভেৰি এইটো খুলি দিয়া না এইটো কিবা এটা নোট এটা আছিলে ধৰণৰ খুলি দিয়াচোন You can place the facts, Mr. Mahant. The order. Oh, just a minute. Date of the order? 1712. Passed in the first case. No. In both the case. In 6117. We have this. Yes. Yes. You can read this.
This court passed the detailed order on 3/11/2025, thereby directing the responsible authorities to bring on report their stand by filing it. Order
that this court opined that the question as to whether there is necessity of passing and detailed order shall be considered on the next. However, on the next time was sought for the petitioner and accordingly this court is the letter of the petitioner, right? It is also seen that was the fifth of 25 when the petitioner was taken up. 1 week's time was again sought for and when it applied, it pursues there to reply was filed on the 15th of 25. And it is however, most of the order, which is 25 with the application service, the issue was into the instance of with regard to the issue of the legal transfer of property. Up to permit the legal process is route number 23. Anapara to Harapur via Gonespuri Flyover. And route number 36, which is from Mandir to Harapur via October. Well, it's 167 members of the Christian Association are flying their buses. So which the council, depending on behalf of the petitioner, submitted that the action taken by the respondent authority is not permissible without complying with the mandate of 6, the Motor Vehicles Act 1988. It is the submission of the Landed Senior Council that the very decision which has been taken to house the 167 members of the association is to accommodate the buses run by the Assam Transport Corporation, which is a state transport undertaking. He therefore submitted that without following the mandate, particular section 99 of the Act of 1988 by quoting his claim, asking for objections and thereupon taking a decision, the respondent authority that no authority or jurisdiction to show. In addition to that, the Landed Senior Council also referred to 7 of the Act of 19. Whereby, only the state government has been empowered to control road transport, including the power to make scheme for transportation of goods and passengers, and to issue licenses under such schemes for promotion, development, and efficiency in transportation with respect to protection and enhancement of the environment. The Landed Senior Council submitted that such power, which is only reserved upon the state government, can only be implemented by whoever location is the official gazette. And since such power being exercised, the regional transport authority has no authority. Our contracts, the Landed Senior Government Advocate appearing on behalf of the state submitted that the section 6 of the Act of 1988 will not be applicable. Taking into account that it is a decision of the regional transport authority to permit the members of the regional association who have existing permits in route number 23 and route number 26, subject to converting their buses to CNG or electric buses. The Landed Senior Government Advocate further submitted that it is not purely a decision only to accommodate the state transport undertaking at the SPC, as it is open to all the members of the association if they convert CNG staff electric vehicles. So far as the submission pertaining to section 67 of the Act of 1988 and the power of the state government to quote this scheme in that regard, the Landed Senior Government Advocate has referred to section 72 to 22 of the Act of 1988 and submitted that the regional transport authority may, after giving notice of not within 1 month, any the conditions of the permit as well as attest to the permit other conditions. The Landed Senior Government Advocate submitted that this also includes the power to alter the specified route. The Landed Senior Government Advocate therefore submitted that in instant case the regional transport authority has done so. In exercise of the power under section 72, section 22 of the Act of 88, and therefore the question of interference does not. This court has given an excess consideration to the respective submissions, and it is the opinion of the court that further deliberations will be required on the applicability of section 6 and section 67 of the Act of 1988. More particularly taking into account that the respondent authorities have taken this decision, as would be seen from the minutes of the meeting. Keeping in mind the suggestions of the managing director of the recommendation of the Commissioner of Gauhati Under such circumstances, suppose therefore we opinion that instead of person early resolution. Accordingly, this court simply send some of final decision or result. Yeah. This court also takes note of that among the 167 members of the Trust Association, 36 members have already migrated or applied for migration to Authorised book in terms with the improved finance society. Four, being behind 151 years. This court further takes note of the submission of the senior counsel or the petitioner who submits that such for migration has been undertaken under force. Neither that this court also takes note of that in some of the cases, the permits of the members either expired or on the verge of expiring, and some are in existence. This court inquired with Mr. and the senior government advocate Assam, the training on behalf of the and the Bora, the council, as to whether the respondent authorities to review the permits of the members of the Business Association or benefits. After instructions, the respective council that the respondent authority to review the permits upon due application. Considering the above, in the next state jobs and cadets as hearing under. Was the members of the Business Association who have not applied or migrated through their are given the ability to apply for the permits on the offensive submitted by the respondent. Thus, applications shall be without prejudice to the present processing. It is for further observed and added that the decisions were taken to convert to groups is subject to the outcome of the revisions, which this court shall consider immediately. This court also observes and directs the respondent authority to have an application by the members of the association, which on the alternative group listed by the respondents is subject to meeting the other requirements. By doing so, the responsible authorities shall apply also to be considered that on the review of the public will be agreeing of its university. So, 1, 2 is already that 1, 2 which my petition survives. Now, can become because basically it's social law, and for that, it's supporting facts. What happened? That the regional transport first took a decision on 28/12/2023. And directed to withdraw 200 buses from the groups of ones.
Where is the decision? Page?
It is recorded in the court order, this court order, right?
165 of which petition? 165.
Notice.
165. 165 is the court's order.
Yeah, say this, that notice.
There was an earlier case by you.
Paragraph 3. This notice dated 28/12/2023 was issued by the authority. There, it says on this, and including the list of registration numbers of city buses, it has been ordered that those city buses have been removed from their authorized routes as per decision taken in the board meeting of the Regional Transport Authority Council. Here on 2012/2023. recommendation to remove 200 classes. There's a list appended to that notice. We challenge it to Commissioner of Report that it cannot be issued on the same.
To remove 200 buses from which route?
8 groups.
From 8 routes.
Then we challenge it that you cannot do it. I will skip those submissions part number. Wait. That regarding 200 buses or to find us that of 4 by submission. Wherever it was indicated. That but then third line.
What had happened to this writ petition 55024? No, this we have seen the interim order. What has happened to this 554?
They allow us. So that is 176. That is your order. With liberty come in. Order of the design, order is the jump by the design. So withdrawn with the liberty to buy the registration. That's the law to further was it. Therefore, it would. Thereafter, you can consider the good, the second. But if we then they issued the notice to us. What you will now come to petition 763. Page 87.
'87.
Let me read it, my lord. Address has been, it has been addressed to an individual bus owner. Then subject lordship will see.
For clarification, Mr. Mohanto, this 7/2/2024 interim order permitted you to apply or what?
Yes, we continued.
Now, what was the interim order?
Earlier.
The which was 550/2024. What kind of interim order was passed?
This was said, accordingly, it is ordered that till the returnable date, the operation of the notice dated 28/12/23, whereby 200 numbers of city buses having valid permits have been withdrawn with effect from 1/1/2024.
That was stayed.
Shall remain
No,
suspended.
that is okay. Thereafter, you are allowed to apply.
You are allowed.
Therefore, you had withdrawn.
Yeah, we have withdrawn.
Okay, then that means in terms of the interim order,
Yes.
you were allowed to apply, and therefore there was no cause of action. You had withdrawn the writ petition.
There, what they said, we have annexed in our miscellaneous petition also, withdrawn. What was the proposal they given to us? There was no such anything. Any condition which have put any restrictions on us at that time, we are allowed to continue with those buses which are flying that time. And as it stood at that stage, thereafter they acted again, issued this notice, 21st November.
21st of November. 21st November.
Yes, 21st November 2025.
Yes, what has happened?
And
Yes.
here, Lordship will kindly take note of subject.
Hmm.
Notice of mandatory rerouting of your stage carriers permit number such and such for the vehicles bearing registration number so and so, as per provision of section 72 of the Motor Vehicle Act 1988. Sir, with reference to the subject cited above, and in compliance with the RTA Regional Transport Authority Board Kamrup Metro Resolution dated 13/10/2025, issued under the purview of Section 72 of the Motor Vehicles Act 1988, I am directed to inform you that as part of the Green City Bus Route Initiative to promote cleaner, safer, and more commuter-friendly urban transportation, diesel-fueled city buses will be phased out from City Bus Route number 23, Khanapara to Dharapur via Ganeshguri flyover, and route number 36, Bashistha Mandir to Dharapur via Polton Bazar, with effect from 1st January 2026. This notice, though it is termed as a notice, this is indeed communicating the decision of the authority that you are compulsory to be gone to another route. Accordingly, your aforementioned vehicle, which is currently plying on route number 23, shall mandatorily required to be rerouted in any one of the following routes of your choice, as per the recommendation made in the joint inspection report submitted by the members of the District Road Safety Committee, Kamrup Metro. Then they indicated these 10 routes. Here, these are the routes they suggested. Next para. Therefore, you are instructed to appear before the office of the undersigned on or before 22/12/2025.
Mr. Mahanta, just a minute. Mr. Chalia, which matter are you waiting for? If you want, we can have it another day. This matter is going to take some time. Unnecessarily, we don't want to keep you waiting. Whenever you want, we can have it. This is, what is this item? Okay, 27, we can have another date. If we are going for a disposal of this matter, this will take at least half an hour more. Unnecessarily, you need not wait. We'll have a date of your convenience. Madam, you inform who is on the other side. Okay, you have a date of your convenience. Okay.
As per my convenience.
Yes, no. Senior counsel ask. Yes.
Yes. So that para says, Mala, after the list, you are
10 options of 10 routes were given to you.
10 routes were given.
Okay, thereafter.
Thereafter, they say you are instructed to appear before this office of the undersigned on 22/12/2025, along with the original stage carrier's permit of your aforementioned vehicle and all relevant documents for mandatory road change, so that your vehicle could ply on one of the aforesaid roads of your choice with effect from 1/1/2026. Important note, they say the choice of route will be allotted on first come first served basis, subject to slot availability, and any bus owner who fails to appear by the cutoff date, that is 22/12/2025, will be allotted a route randomly. Such owner shall be required to operate his or her bus on the randomly assigned routes with effect from 1/1/2026. So this notice was put to challenge that you cannot do it like this. This is an arbitrary order. First thing, my ground was that, see, you talk about Green City Bus Route Initiative. So when you talk about this route initiative, that means there is a scheme we have to understand. You take certain step to go into the field with a view to safer, cleaner, and what they call it, more commuter friendly transport, urban transport. And therefore, you want to gradually phase out the diesel fuel vehicles. You must have prepared a blueprint for that. You must have some scheme for that. If this was so, you ought to have notified it. You ought to have told us beforehand. And under the law, you are required to float such schemes in public domain and ask for the objections,
Objections.
if there is any from any quarter, and then you may go ahead, and then, yes, courts will be open to you to take further action as may have been provided under the law. But you have not done it. Therefore, this action cannot be allowed to sustain. Meanwhile, what they did, they force us. Lordship will kindly come to page 92. 92. Whenever a permit is required to be renewed or approaching the renewal date, they went to the office and they compelled them to sign this undertaking, and they have taken this undertaking by force. It says so and so, so and so, so and so, the name of the bus owner, number of the bus, permit number and all. And then it says that I will abide by the resolution, third line, that I will abide by the resolution number 2-1 of the RTA board meeting dated 5/4/2025 and the order of the chairman RTA Kamrup Metro that the permit of route number 23 and 36 must not extend beyond 31st December 2025. Therefore, I assure you that I shall not ply my diesel operated city bus with vehicle number such and such in the existing route number 36 from 1st January 2026. That, madam, I kindly request you to renew my permit for 6 months for the last time, and thereafter I would like to confirm that I shall change my existing route number 36 to new route number 39 during the next renewal of my stage carriage permit number so and so. These these permits were existing, some of them are still existing up to 29. Up to 29. They wanted that no, it is on 6 monthly basis only we will do it. If you accept and give the undertaking and go ahead. This is how they compel us to act.
What is your averment towards this?
My averment
Annexure
is
8.
Annexure 8. Kindly see at page 12, Lordship will find. Huh? 11. 11, Lordship will find. Page 11. Upon B, my lord, that statement of paragraph 6. Then B, upon expiry of the 5-year permits of route number 23 and 36, the respondent authorities have been renewing the said permits only for short duration, ranging from 3 months to 1 year, and in any case not beyond 31/12/2025. At the time of renewal of the said permits, the respondent authorities are refusing to renew the permits unless the members of the petitioner association
You
are
have verified properly.
accepted that,
Mr.
my
Mohanto,
lord.
verification is poor. Verification is as per records. How do you make an allegation of forceful signing as per record? These are personal things.
1 to 7.
How do you believe this?
My lord, Lordship is right. Yeah.
Affidavit is the only thing we
Hitu
check.
tasani kya hua? Aur hitu tasani. Huh? This is a mistake. I must own it. I must own it. And here,
Why
but
should you own
nonetheless,
it?
this is not denied by
Why
them.
should you own it? You have invented this mistake
No,
while drafting the petition.
my lord,
They had very willingly they had signed this.
my lord, even then, my lord, the agents are there. So I cannot escape the responsibility. Probably I didn't see it that time. So slight mistake has taken place. I think my associates will be in future very careful about.
Whatever is in record, we'll go by the records.
Anyhow, Malad,
Okay.
if your lordship takes it, that
But
there was
this
no harsh-
doesn't look like a coercion, because see, you are still given 6 months time to renew, and in the meantime, you have also accepted that existing route you allow me to permit fly, and after 6 months, I will change to another route.
We signed this.
Malad,
That is why we said it's fair.
in fact,
You may
factually-
be correct in contending that it was not a very balanced or fair
Yes.
treatment.
Yes.
They were under some coercion, but
Malad, what they did, that unless I sign this, they will not take anything from me.
that might have happened. As a matter of fact, it must have happened, but we'll go by the whatever you stated.
Here, it ought to have come in the affidavit,
Mm.
in the knowledge part. There it is not there. I mean, if you reply quickly. Sure, reply. Reply. Now, well, what is their reply? Let me see, because on this particular context, Lordship is asking me. Hmm? Control? Paragraph number 6. Here there is nothing. They have not denied it. Even affidavit in opposition. 6117. I cannot keep a say. Punto.
Paragraph was in the reply down.
There was also no denial, my lord.
There is no denial. You are correct.
There was no denial.
What is this new trend, madam, of filing affidavit
Yes.
that you do not deal with the paragraph? What is this? You have for the second time. What is this trend going on? You don't follow the spirit of CPC. No denial. What is paragraph 4? That instead of giving a paragraph-wise reply, the deponent at this stage deems it appropriate to confine the present affidavit to the extent of disclosing the stand of the deponent. If there is no denial, how do you have to admit that these are undenied, not denied.
No, these are not denied.
There is no dealing with the averments. He has made a very serious averment. Yes, his affidavit is improper, but averment is nonetheless there. You have not even dealt with that. And why is this trend? Why do you feel it difficult to deal with the averments? What is this kind of? It's not a written statement in a labor code that individual stand would be reflected. You are responding to a petition, writ petition.
And it has to be decided on affidavit only.
Yes.
So, my lord, my statement remains. They have not denied it. And lordship, as it has fallen from your lordship, that otherwise it can be presumed that they have applied force to get these documents signed. Because otherwise, they denied all kind of.
Thereafter, what has happened? You gave this undertaking on coercion. Thereafter,
Not all, my lord, some of them, not all, few have given. That's how it was obtained. That is only I have placed it. I have placed it. Now, thereafter, what happened? It's like a root
The
change.
permits been filed.
Kindly see, I would like to place few permits, my lord.
80, page number 80.
Page 80, Lordship will kindly turn to.
80.
Yes.
If it was just left, like permit book, 28, 27.
We have given a chart indicating the vehicle number, owner's name, and permit number, road number, and permit validity. Lordship will find here,
25 was like 6 months or so. They have been renewed for
uh,
1 year.
right-hand column extreme, that first few are 25 up to 25, 15, 5, 20, 15, 11, 20, 25.
They have been
Then
renewed for 1 year.
uh,
They have been renewed for
these were only extended up to 31st December 2025, not beyond that. And thereafter,
But there are few which are up to 27, 29 also.
27, 29,
29.
Lordship will find 27, 28, 29, 27, 27.
given the sample copies on page number 1.
And then next page also 81, 28, 27, 27, 28, 29.
Sample copies.
This, and as a sample copy, Lordship may like to see.
That is okay. You want to argue perhaps that the permit extends to a particular time, and in spite of that, in the midway, it has been
Yes.
there has been change, and you have been caused
prejudice.
prejudice.
And their action is not permissible under the law. That is my case. Now, that being the position, now they
For
want.
that, you have contended to section 99 of the MV Act.
Yes.
No objections called for,
Yes.
and the other procedures prescribed not followed. And
Nothing.
67, you have taken another ground that it is the state government which is
Yeah,
empowered,
who is to?
not the Road Transport
Not the
Authority,
road transport authority.
RTA. So these are mainly your two grounds.
Exactly.
And you are supporting your grounds by stating that
They cannot change the.
Yes. No, Malad, firstly, whether under section 72 or
72,
27.
27.
72? Yes, 72, Malad.
Yes. What is 72?
72 grant of stage carriers permit.
No, the RTA may vary the condition. 72
Vary
says.
the condition, but
Yes,
that
yes.
does not. Here, the power is not given to change the route itself.
But 72 is taken aid by the state. They say state that we are empowered. RTA is empowered by 72.
RTA is empowered. Well, my first submission is, if they claim that they are empowered to do it, they can act only under section 72 as they claim. And they invoke for that subsection 22.
Yes.
22, here they say
72 to 22.
222, that the regional transport authority may, after giving notice of not less than 1 month, vary the conditions of the permit. Attached to the permit, further conditions. Condition of permit, whether the condition of permit includes the road itself. For that, Lordship may also see the first 22 to 1, Roman 1.
No, to put it simply, you say that this action, impugned action, would not be covered by 72 to 22. That is for a limited purpose.
Yes.
And we have exceeded that powers.
Power.
And if you exceed, it is the state government's prerogative. State government has not done this.
Not done this. And what I find,
Supreme Court judgment to that.
I will place the Supreme Court judgment also at this point.
Yes.
My lord, here, the authority now, from their affidavit, I have found that they have acted not only 72, they have invoked 103. Section 103 also.
হেৰিখন লাগিব একখনো লাগিব
Because Motor Vehicle Act. It is going to break up.
Block number 8 है, 82.
103.
Yes. Yes, already by your permission. 103 comes under chapter 7. Sorry, 6. Special provision relating to state transport undertakings. 103, it says, straightway, issue of permits to state transport undertakings. Number 1, where in pursuance of an approved scheme. Lordship will kindly note, any state transport undertaking applies in such manner as may be prescribed by the state government in this behalf for a stage carrier's permit or a goods carrier's permit or a contract carrier's permit in respect of a notified area or notified road. The State Transport Authority in any case where the said area or road lies in more than one region and the Regional Transport Authority in any other case shall issue such permit to the state transport undertaking notwithstanding anything to the contrary contained in chapter 5. So it excludes chapter 5, my lord. Chapter 5 includes 72, section 72. Now 2 is important. Subsection 2. For the purpose of giving effect to the approved scheme in respect of a notified area or notified road, the State Transport Authority, or as the case may be, the Regional Transport Authority concerned, may, by order, then it says, A, refuse to entertain any application for the grant or renewal of any other permit, or reject any such application as may be pending. So only then they can exercise this power. Otherwise, they are bound to accept. I will come to that provision also, that it is to be automatically renewed by permit. B, cancel any existing permit. They can cancel only under section 103 to C. Cancel any existing permit. C, modify the terms of any existing permit so as to render the permit ineffective beyond a specified date. Now suppose, my lord, pausing for a moment, my license permit or license extends to 29. If they want to modify it, they will have to invoke this power. And for that, the government have to act first. And indeed, the government initially wanted that you go in accordance with law. They have placed that record. I will take it, your lordship, to that also. You try, but government never framed any scheme or notified any scheme, nothing. How come the regional...
What is the disclosure in the affidavit?
In their affidavit, I will take your lordship to certain documents they have annexed. Precisely, what coaching not?
It's 117 or affidavit of input. Evidence can.
Well, their affidavit in details annexing those documents, lordship will find at 6117 of 2025. Kindly take up that affidavit. That is the first read petition.
Who's the affidavit? Affidavit of R3.
R3. This is here, my lord. R3, yes. R3. District Transport Officer and Secretary Regional Transport Authority.
Yes.
They first rely upon this at Annexure A, page 132, lordship will find.
Of that affidavit?
Yes, of that affidavit.
They say this is the extract of the minutes of the cabinet meeting held on 28/20/21. Let us look into it. If they want to say this is the origin, where from we started walking.
Yes, this is the minutes of meeting dated 28/2021.
Yes, of the cabinet. It is agenda item was additional item number 11, Transport Department. Subject is procurement of 200 electric buses for operation in Greater Gauhati city and suburban areas, and creation of required infrastructure for operation of this fleet. After detailed deliberation, Cabinet approved the proposal with following directions. 100 CNG operated buses for plying within the Gauhati metro be procured with Gauhati Smart City Limited Fund and operated through Assam State Transport Corporation in Greater Gauhati area and on revenue sharing basis between GSCL and ASTC. Budgetary provisions, all that should be made. Then 3, Lordship will see, to make the metropolitan city free from carbon emissions, ASTC shall stop running petrol, diesel buses within the city area first. The department was also directed to explore the possibility to stop plying of private vehicles, buses within the city area in a phased manner. 3. Condition Roman 3. Decision said definite is metropolitan city free from carbon emission, ASTC shall stop running petrol, diesel buses within the city area first. The department was also directed to explore the possibilities to stop plying of private vehicles, buses within the city areas in a phased manner. Committee constituted for guiding the entire process with the following members. This was the committee. Now, whether this committee took any decision to go further, formulating a scheme or fixing a certain timeline, nothing has come forth. Nothing has come
But
forth.
this was of 21.
Sorry, it was in 21. It was in 21. Then in 23, what they did, Lordship has seen, they initially directed to withdraw all the buses from the flying in and around Gauhati city. 200 buses were directed to withdraw. We came there, how can we act like this? We are having the permits, authorized permits. We are running it according to law. We are paying. Life and livelihood of so many people are involved. How can you ask us to withdraw? This court stayed it. Then they said, then no, go ahead now. We allow you to apply. Go ahead. So we had withdrawn that. And thereafter, now they say that in Green City Bus Route Initiative, we want that we should be mandatorily changed. We'll change you. No opinion, nothing of this sort. We'll change you. You will have to go. Whether this is permissible, that arbitrary action is not permissible under the law. Who authorized them? How can they do it? This is the resolution taken by the RTA board. RTA board decided this. They have
No,
not.
but this decision has emanated from a cabinet decision of
But-
2021.
Yes.
Now, we have to trace back the decision to this minutes of meeting of 2021.
Yes.
Uh,
My response submission is the cabinet has in the year 2021 itself
yes,
took this decision that the STC shall stop
yes.
first.
STC will stop flying fuel generated vehicle.
Diesel or petrol.
Fuel.
Oh, yeah, fuel.
Yes.
Fuel-fed vehicles.
They'll stop. Mm.
And then the department was also directed to explore the possibilities to stop flying the private buses. Fuel-fed. Possibilities. whether this was possible, if so, how to go about. That committee was also formed to suggest. We are in dark. What was the opinion expressed by this committee?
No, what is the meaning of this expression? The department, serial number 3 of that minutes.
Was also directed.
Directed to stop flying of private vehicles. What is a private vehicle?
Explore the possibilities.
Yours is not a private
Yes,
vehicle.
Yes, private vehicles means all vehicles, all private vehicles. That transport vehicles, it doesn't say.
Private vehicles means what?
Private vehicles, to my understanding, it will include all the vehicles which are privately plied,
But
not owned by the STC.
Yours is a commercial vehicle.
There is a commercial vehicle.
It's
with
not a private vehicle.
stage carriers vehicle.
What do you mean by private vehicle? Private vehicle is the one which is owned by you, a private individual. But if you have a vehicle which has got a commercial registration, that is not a private vehicle. It's for commercial purpose.
I
Now
owned
this
it
decision-
privately, but commercial purpose with the authority.
The word buses is also there.
No, we are not on the expression buses. We are on the expression, what do you mean by private vehicles? Possibility of applying of private vehicles. You cannot stop private vehicles.
In fact, the entire issue in this relating to buses, public buses is there.
No, that oblique is there, but why? What is the meaning of flying of
No,
private
the-
vehicles?
The entire discussion is under the buses under the STC and the buses, not as regard the private vehicles, small vehicles. In fact, the
Maybe
entire-
the
But
meaning
what
was for buses which are operated under the STC, not
Under the-
STC buses,
under the STC.
the mini buses,
Yes,
the canters and all those.
Yes. This discussion and all these things and that the initiative taken was first of all, Lordship will see that to make the metropolitan city free from carbon emissions. That is the object, and with that object, the decision was taken. Picking one word from some sentence.
No, he has not taken up the. We wanted to get the clarification.
this malad wordings used here
Yes.
is not the question of picking up a certain word to suit my purpose. Not that. Here, Lordship has rightly pointed out the department was also directed to explore the possibilities to stop plying of private vehicles / buses within the city area in a phased manner. Let me accept it, presume it, that private vehicles means minus the vehicles owned by private individuals. And it includes only those buses run on permit issued by the government.
Correct.
under
Perhaps
the-
that is what they had meant.
Yes, let us accept it. Even if for that purpose, they said you explore the possibilities, whether this can be done,
Done.
and see to it. For that, advisory committee is formed. What the committee said, how to go about, whether it was feasible, plausible, this aspect was there. Cabinet didn't say that this is possible, you do it. But cabinet was definite.
To explore.
Explore. Cabinet was definite in case of the buses run by ASTC. Said, you stop first. Then you explore the other possibilities, because private vehicles includes, it has a very wider impact. In one of their reports, the DTO himself has said that 11 lakhs vehicle ply in the Gauhati city every day. 11 lakhs vehicles. That is their report. I will place it. Therefore, there is a necessity to explore the situation, how to regulate it. All of a sudden, you cannot, at the throw your hat, decide that you stop on from this and will do like this. Because it involves the livelihood, employment of so many people. And public convenience, inconvenience also. Lordship, if I may say, sir, during this rainy seasons, when there is artificial waterlogging in the all roads, these buses stop. These electric buses, they cannot fly. We had to come in. We had to come in, only the diesel fuel or the petrol fuel buses can only run in water, not the electricity. Because even they cannot keep their lights on for a long time, because it's it affects the battery and the battery goes down.
Page number.
11 lakhs vehicles they ply every day. That is what they have said. Page 126. I will come to it. Now, thereafter, my lord, this was the beginning in the year 2021. What prevented them to meanwhile go ahead? They got enough time. 21, 22, 23, they suddenly issued a notice. You stop 200 buses.
What about the working by this committee at 4? Committee had made some recommendation.
Well, nothing has been coming on record. They have not said anything. We do not know. Nothing has been put on public domain. Here also, they have not come up with clarity that this is what the committee discussed or said or resolution was adopted. We are in dark. And so far, we are concerned as the bus operators, we are not given anything, we are not told anything. We run our buses, we see to it that the buses are worthy to run on the roads and they run properly and public inconvenience is never caused. Therefore, what did committee suggest? What resolutions this committee adopted or suggestions they provided is not on record. We do not know, but fact remains that the possibility to explore was never done as it appeared to us. If suddenly issuing a notice to withdraw all buses is the nature of exploration caused by them, I am afraid this is arbitrary. This is not the proper way because it doesn't conform to the legal requirement also. We cannot ignore the law prevailing, holding the field, which is regulating the entire system now. All of a sudden, you cannot just put it otherwise. Whole thing will go topsy-turvy. Therefore, and then Lordship will kindly come to next page there, affidavit 135. Here, this is the special RTA board meeting of Kamrup held on 2012-2024. Annex C, page 135. মই যিকেইটা নোট কৰা থাকিলে একদম মত লগত গোট ক'ত আছিলে সেইকেইটা আমাৰ লগত কোইনচাইড কৰিছে মোক ক'ত আছে লৈ থাকা এইটো keep it in your hand, give it to me as and when I need it. Here, my lord, this is held on 2012-2024. And
Mr. Mahanta, how long will you take, Mr. Mahanta?
it will, my lord, take another.
No, Mr. Sahil and Mr. Sharma, I don't think your matters can be taken up. Mr. Chaudhary, some debarment matter, why are you not available in the court when matters? I mean, other occasions you are not found in the court. You have to be specially invited. What is going on? Here's some urgency in the debarment case.
It can be taken up tomorrow. Also.
Tomorrow, we cannot say.
Tuesday, madam.
Tuesday, we may try. Tuesday, Tuesday, unnecessary, we don't want. Mr. Sharma, which matter? 34. Is there any urgency? We can have some matter. And there was another mention. Yes, madam, which matter?
Lordship 28, Lordship.
We may not be held today. Have some date, give it to court master. Monday, what is the matter? Is there any urgency?
That, so 90 days.
Power line?
They have proposed a power line.
Yeah, for the petitioner. Other side, APDCL. We're going to try on Monday then. Did to look at it. Go late.
29, I can bring an instructor to them. I don't think
29, who's 29? Petitioner? Petitioner?
It may be.
Who is petitioner? Name of the council?
Well, also we can fix some things in that matter also.
If the petition council is there, we can pass orders. We can note it down. Otherwise, no point. This is going to take some time. Mr. Sharma, your other matters perhaps will not be possible today. Give a date of your convenience, we will have it. Okay? Mr. Sharma also. Which matter?
That matter I have received instruction, it's become instruction.
You are in 29. No, who's for the petitioner? Unless the petitioner's counsel is there, we cannot dismiss as infractors. No, madam is saying that it has become. We can record his presence and then only. Without him, it not be the proper. Monday. Okay. Date करा दीदी का विनय लिख लो सब करा date.
Now,
29 is the council there. Has it become infractuous? Just, Mr. Mahanto, just a minute. We want to give you space.
yes.
Only for your convenience, we are trying to make
Let them
space
have-
for you.
Let them have.
You can also take a break, 2 minutes break. Yes, what is it? Madam Dr. Bora,
Yes, Lordship. Regarding blacklisting of clerical manner, it has been removed, the second paragraph.
Oh. Okay. What is your name?
J.A. Sikdar, Lordship.
J. Sigdar. Heard Sri J. A. Sigdar, learned counsel for the petitioner. Also heard Ms. M.D. Bora, learned standing counsel, Transport Department.
Finance, Lordship.
Transport Department. Post of. The grievance of the petitioner is with regard to an action of blacklisting. Full stop. Para. Ms. Bora, the learned standing counsel has however submitted that there are written instructions dated 25/5/2026, as per which
Very clean question.
the blacklisting has been removed. Full stop. The learned standing counsel has placed the written instructions dated 25/5/2026 on record. Have you gone through? Is it okay? The learned counsel for the petitioner has endorsed the submission. Has submitted that in view of such subsequent action, there may not be any live cause of action which requires adjudication. Full stop. Also heard Dr. H. Amma for the ASTC. Para? In view of the aforesaid development, the instant writ petition is closed as infractuous.
Lordship, I can keep.
Written instructions dated 25/5/2026 along with each ITS enclosures, each enclosures are made part of the records.
You oblige, my lord.
You had any matter, Mr.
Yes,
Bhattacharya?
sir, item 26.
We have a date. Today it may not be possible.
Well,
Other side,
well, state.
we'll try to finish Mr. Mohanto's matter.
So I was referring to page 135, Malak.
Yes. That RTA, special RTA of 2012,
Special IT board
2024.
meeting dated 2012-2024.
Yes.
And here, Lordship, they are the members of the RTA board only. Present there. And I will take your Lordship to page 137.
Abjay, Avadaj. ये कंप्लीट भी होगा तो सेव भी होगा ये, तो आराम से होगा।
Here it says,
नाम
Malak,
लिख कर
that serial 3.
You are reading 137.
Yes,
Yes, serial number 3.
3.
Green City
Green
Bus
City
Route.
Bus Road. This is. As suggested by the MD ASTC
Yes.
and recommended by the DCP Traffic Guwahati, the Honorable Chairman RTA Kamrup Metro directed the DTO and Secretary RTA Kamrup Metro to explore opportunities in gradually phasing out the diesel-operated city buses plying on city bus route number 23, Khanapara to Dharapur via Ganeshguri flyover, and route number 36, Bosistha Mandir to Dharapur via Palton Bazar, so that by January 2026, only electric buses could ply on these two routes, aligning with sustainable and eco-friendly transportation objectives. Now, here, well, the very first opening line itself suggests, as suggested by the MDSTC, as per suggestion and recommended by the DCB Traffic Guwahati. This is the only information we get, that under the recommendation of the DCP Traffic Guwahati and as per suggestion of the MDSTC, they authorized the DTO Secretary Kamrup was directed to explore opportunities in gradually phasing out the diesel operated city buses.
Yes.
And in particular in these two routes. Lordship will kindly now recollect that we have thereafter been issued the notice on 1/1/2024. Notice dated 26/12/2023, 28/12/2023, asking us to withdraw 200 buses from 1/1.
Where do you find that notice?
2024. That interim or the order I placed Justice Manish Chaudhary. That order, there it was written. That in the first writ petition, which was withdrawn initially. In 2023, we were issued notice on 28/12/2023, asking us to draw our buses, that is 200 buses were directed to be withdrawn from the routes in and around Guwahati city. To order to. At page probably it was
164.
154. Yes.
164.
164, right, 164. There it was noted. They issued that notice to us. We challenged it. That was stopped, and they admitted that no, now we know. Then the notice again in 25, that was issued. So here also, I would like to now point out that regarding that committee was formed by the cabinet. There is nothing about the committee's report or committee's suggestion. Nothing is there. It appears that the committee has never suggested anything. It was only on the basis of the suggestion of the MD, STC and the traffic DCP. One more point I would also like to point out here, not in display, page 141, Lordship will kindly turn to.
Same, earlier repetition.
Yes, the affidavit in opposition. In affidavit in opposition, we are referring to 6.
No, understood, but 6117.
6117, yes. Affidavit filed by them. Page 141. This is another minutes of the RTA board meeting dated 5/4/2025. 5/4/2025.
25.
Yes.
Okay.
5/4/2025. This document is Annexure 11 in my writ petition, page 113. It will work.
Yes.
113. Oh, 726 it will work. Here I will point out, my lord. Designation of city bus road number 23 and 36 as green roads and renewal of stage.
Where are
carrier
you
permit,
reading?
Page 144, my lord. Wait, no? Page 144. I'm reading their affidavit, their document.
Yes.
This says the heading is designation of city bus route number 23 and 36 as green routes and renewal of stage carriers permit of diesel operated buses plying in Kamrup Metro.
Yes.
From the top, the ACT, Assam, and the DTO and Secretary RTA Kamrup Metro informed that as per resolution number 10 of the RTA board meeting held on 2012-2024, the MTAG has submitted an affidavit seeking withdrawal of the Honorable Gauhati High Court's case number so-and-so 550-2024. That was withdrawn earlier, Mala, that case. This follows the decision to allow the remaining 46 buses out of the original 196 involved in the case to operate under their previous stage carriers permits. The DTO and Secretary RTA Kamrup Metro further informed that approximately 169 diesel-operated buses, including 19 of the 46 aforementioned buses, are currently plying on city bus routes number 23 and 36. These routes have been designated as green routes as per RTA board resolution. So 169 buses, diesel buses were there, including those 19 of the 46 aforementioned buses in these two routes, 23 and 36. In this regard, the RTA board resolves that the renewal of stage carriers permits for these buses shall be granted on a 6-month basis, similar to the process of diesel-operated buses on other routes. They have just cut short the period of permit to 6 months. I will come on. This is also not permissible under the law. Here they have taken this decision. However, the validity of permits of buses operating on route number 23 and 36 must not extend beyond 31st December 2025. This is their decision. Beyond 31st December 2025 must not extend. The DTO and Secretary RTA Kamrup Metro shall ensure strict compliance with this deadline. Therefore, notice was issued to us. The DTO and Secretary RTA Kamrup Metro shall immediately arrange a meeting with MTAG, that is our organization, to inform them of this decision. The objective is to explore alternative routes for the buses post 2025. The bus owners may also be encouraged to switch to CNG or electric buses in order to continue operation on Route 23 and 36 beyond 31st December 2025. They have taken a decision. They should be at any rate withdrawn from those routes. Also said the bus owners may also be encouraged to switch to CNG or electric. Addressing the issue on non-reciprocal permit fees. What happened, my lord? They issued license, renewed license for 6 months, but they charged the fee, which is far more, nearly the fee charged for 5 years. Normal fee, which is charged for 5 years. Tenure of a permit is 5 years. There is a price fixed for that. Slightly below that amount that used to charge for 6 months. That was objected to by our association. So therefore, what they said, addressing the issue of non-reciprocal permit fees, where a 6-month stage carriers permit costs rupees 2150, while a 5-year permit costs 3150. 5 years 3150, 6 months 2150. That is the difference. The Honorable Chairman directed the DTO and Secretary RTA Kamrup Metro to report this anomaly to the Commissioner of Transport in order to ensure financial fairness for bus owners. They agreed that this is unfair, disproportionate. It cannot be. It should not. It is not reciprocal to the period. Sorry. This much relevant here, my lord. So it says here from also it appears that the ACT, if I can, Assistant Commissioner of Transport maybe, or the DTO, at their instance, the RTA board took this resolution and they enforced it from 1st of January 2025, fixing it the deadline of 31st December 2025. Then, Lordship will kindly turn to at page 153, my lord, this is minutes of the meeting held with the Metropolitan Transport Association Gauhati with us. They have maintained a minutes. What transpired there, Lordship will find. Annexure E. My lord, at page 153, welcome and objectives. There, Lordship will find a column permit validity restrictions.
Yes,
In the middle, my lord.
yes, sir.
We raised this issue, validity of permits for buses operating on route number 23 and route number 36 shall not extend beyond 31st December 2025. These routes will be designated as green routes effective from January 2026. So this designation was given by the RTA board. So they wanted that this is designated routes, we will not allow you. Then addresses by key stakeholders. Here, Lordship will see. B, I will place the B. Sri Gautam Das, OSD, Commissionerate of Transport, Assam, DTO, Kamrup, stress the importance of converting city bus routes to green routes to reduce tailpipe emissions, especially in the busy corridors of route number 23 and 36. He stated that approximately 11 lakh vehicles operate in Kamrup Metro and suggested the extension of city bus services to suburban areas like Zagrud, Vijaynagar, Bayatacharili, Haju, and Swalkusi to provide economical and efficient public transport access. It is their opinion that 11 lakhs vehicles operate. Now, kindly come to down below serial 3. Interactive sessions with MTAG.
MTAG is you.
Of my organization. An open mic interaction session was organized to clarify queries and concerns. Several bus owners and associations members raised concerns regarding the cost of conversion from diesel to CNG and the associated operating expenses. In response, Srimati Tamsin Aftab requested, this is the chairman, requested all stakeholders to submit written petitions to the office of the DTO, Secretary RTA Kamrup Metro, so their concerns and suggestions could be presented before the RTA board for further consideration. That was the transpired there. Rest, Lordship may ignore. We submitted our concerns, representations regarding that non-reciprocal fees also. That was taken by the authority and forwarded to the commissioner, page 161, their affidavit 161. They indicated to the commissioner that yes, it appears that there is some discrepancy here. It should be reciprocally fixed. But nothing has been done till today. And from our side, we, in our application or representation at page 162, categorically said that we cannot, it was on 5/7/2025, they have accepted. We have responded by filing this pursuant to the resolution or the minutes of this RTA board with us. The pre-page we have already submitted. It's short letter. I am writing to inform you that the RTA board meeting held on 8/4/2025.
What is the date of this letter?
It is down below, Lordship will find 5/7/25. That by hand written, this was received on that day, 5/7/25. Oh, at top also, after this addressing date 5/7/25 at Gauhati. This date is there. Yes. 162. I am writing to inform you that the RTA board meeting held on 8/4/2025 proposal to remove our diesel operated mini city buses from route number 23 and 36 due to the introduction of e-buses at Gauhati city. Consequently, the RTA authority directed us to convert our diesel operated city buses to CNG operated buses for route number 23 and 36 before 31/12/2025. After consulting with our road bus owners members in a meeting held on 25/6/2025 at MTAG office, VIP Route 6 Mile, Gauhati, after discussion with the respected city bus owners of route number 23 and 36, it was decided that accepting the RTA board's proposal dated 8/4/25 is not possible for us due to present financial condition of the owners members. On behalf of all MTAG members, I, Sri So-and-so, Secretary, hereby unable to accept the proposal. This was conveyed to them. Then we submitted a detailed representation at page 163. This was also with them, asking the authorities not to implement that resolution and to cooperate with the MTAG. Then, Lordship, I will take your Lordship to the next page, 168. This is another minutes they have annexed here. It is minutes dated 5/8/2025 of the board. Here, Lordship will find 169 page, number 1, column 1, topic, designation of city bus route number 23 and 36 as green routes. It says, resolutions. After careful consideration of all the previous resolutions taken in the RTA board relating to green route resolutions, the meeting conducted with the MTAG and city bus owners dated 5/7/25 and the memorandum submitted by MTAG dated 5/7/25, the RTA board approved the following directives. Green route resolution continuation. The RTA board affirms that it cannot reverse the earlier decision taken in this meeting, its meeting dated 5/4/25, resolution number 2, concerning the green route resolution for city bus route number 23 and 36, especially in view of the upcoming induction of another fleet of 100 numbers of e-buses under the PM E-bus Sewa scheme expected to be operational under ASTC by 1st January 2026. My lord, here they speak of E-bus Sewa scheme. If under this scheme they have done it, who has floated this scheme? How was it done? That was also not coming forth, not even to this court. There must be a scheme. Otherwise, they cannot do it. They cannot suddenly take a call. RTA board is not authorized to do this. They have the power to only regulate the buses which run within the state under the law of 72. But when it comes to a special provision, floating a scheme, allowing some specific buses to ply, ousting some other classes of vehicles, or prohibiting some other classes of vehicles from plying on those routes, in that case, they are not the authority. They will have to take the help of the government. Government will have to come in. And it says permit renewal for CNG fuel buses. It doesn't, my lord, I am not CNG. It says only we can convert within 31st, which is not possible. It is very costly and not possible to us. Then they have also relied upon these undertakings at page 181. These copies they have
Mr.
given.
Mahanta, we have understood your case more or less. That first you are questioning the jurisdiction of the
Yes.
authority of the RTA. Next, and you have also stated, you have also taken the ground of violation of statutory provisions of 99 and 67. And whatever steps have been taken by the RTA would be beyond the powers conferred upon them.
Yes. And when they have admitted that they want
And
to-
most importantly, they have not taken a balanced decision
Yeah.
without giving you an opportunity,
Yes.
or without thinking of your means of livelihood.
Yeah, exactly.
This will
Because- yes,
primarily be your ground.
Exactly, but I am grateful. Basically, the whole object of the new Motor Vehicles Act is this. Even they talk of public-private partnership. I will come to it, but I will place it, that object also.
Was the option given to you to convert to E-mode?
No, nothing. They said that you convert it. You convert it just. Right. Firstly, all of a sudden, this cannot be done. And Lordship will
No,
appreciate
this will involve a huge expenditure.
huge
That is okay.
expenditures.
But gradually, in a phased manner,
Yes,
perhaps.
you give us that within 2 years, 3 years.
See, we cannot really find fault with the change of policy, which is in terms of the global need
Yes,
to reduce carbon
yes.
emission.
Yes.
But whether we have to see whether it's been reasonably
Exactly.
introduced and
Bala,
done.
kindly consider these buses are BS3 4 compliant.
Yes?
BS3
Yes,
4
yes.
compliant.
The latest, yes.
Latest, these buses. So emission is very minimal because those are upgraded. And that's how new buses, Lordship may have seen, they ply day in, day out before your Lordship's house. These buses are not those old city buses. Those are abandoned long back. Right from the beginning, from the inception of the city buses are being plied by these associations.
We'll
So
do
they are
one thing.
upgraded.
We'll have to continue on some other day. I think you'll need some more time.
Little more time will be required.
But more or less you have.
Yes,
sufficient-
I am just coming to complete their part, and then I will, Lordship has taken note of, I will clearly law only place it that Lordship will go by this.
Today we'll have to rise, there's a meeting, but next week, but not, we like to have it without much of a gap.
Yes,
that
yes.
there is
Well, if
continuity.
possible tomorrow also.
Tomorrow may not be possible. Tomorrow we'll be rising early because our director is retiring from academy, Justice Ali. So some of us need to be
Oh,
there.
there. Yes, yes. He has given service even
Yes.
after debiting official.
So, lot of things we have to take care.
Then on Tuesday, Mala.
Tuesday কেনেকুৱা আমাৰ schedule? Tuesday বা Wednesday দিব পৰা আমাৰ Wednesday. We can have it on a motion day because motion days matters gets over very early.
All right, but as per your losses convenience.
Wednesday, next week itself we'll try to Wednesday.
If lordship,
Wednesday.
if lordship permits, I may also mention in the morning that.
Yes, we'll immediately as the first
Okay. mention
first
to-
hearing
Yeah.
item or first my item for disposal.
Yes,
After the motions,
yes,
even for admission, the hearing will not take up, we'll take up your matters.
exactly, Mala. I am grateful. Then it will be
Yes.
finished on that day.
Hearing has लिखित हो दिया. Hearing has remained inconclusive. We thought of completing the matter, so hearing has remained inconclusive. List for further hearing on Wednesday.
Yes. Deeply obliged.
But Wednesday you complete
Yes.
within half an hour,
No,
then
I-
we'd like to
I
hear
take half
Mr.
an
Nath
hour.
and Madam.
To complete, then lordship may hear them. It was a way, it more not going to buy kind of.
And case laws which you'll be relying upon, you can, Madam, you can make a compilation and
Yes.
only the relevant paragraphs you can make a mention and I'd like to go through. এইখিনি ইয়াতে থাকিব টিউজডে আৰু আহিব তাৰমানে নোটটো ইয়াতে ভালে নথওঁ নেকি বেলেগকে ইয়াতে থৈ দিব টিউজডে এইখিনি আছে ইয়াত লৈ আনিব এইটো ছুটি হয়ে যাবে